provision of a sports pitch, erection of a pavilion, and formation of an associated car park. And of course the site is the former Brandon Stadium, close to Coventry. So before we start today, the usual housekeeping matters. Mobile phones, can you please turn them off or on to silent, please? Laptop notifications, can we also turn those off as well if you're able to? Anybody intending to record or film the event? No. Good morning to the press. I see you're back with us today for our last day to see clear closings. Good morning to you. Fire evacuation. We had a fire drill yesterday, so hopefully we won't be having one today. So if the alarm does sound, it's likely to be a real situation. So we're asked to make our way down the main staircase, out of the main doors of the town hall, then to congregate at the entrance to Caldecott Park. Then an officer of the council will then let us know when it's safe to re-enter the building. So when we finished the inquiry back in end of September, there were a few outstanding matters that were to be picked up on. Some questions that required an answer from the appellant, and I had received an email or a statement in answer to those. That related to distances to the 3G sports pitches that were discussed, the relationship between Brandon Estates and St Phillips Limited, and also about the discount for affordable housing. Now, as far as I'm concerned, that answers my questions and provides the additional information that I require. But I know the Rule 6 party in particular was seeking this information. Is that to your satisfaction now, Mr. Humphreys?
Madam, in relation to taking those three in turns, the distances to the 3G pitches, we had understood that there was going to be a joint note. Do you remember? You may recall right at it, and Mr. Davis, who sits behind me, spoke to Mr. Hooper on the very day when we adjourned. We hadn't heard anything until last Tuesday afternoon when we received what was clearly not. So what we did was to put in what we had discussed on that same day, as I understand it. So I appreciate that originally there were just two questions. One was about Mount Nod and the other was at St Finbarr's. And I think during the discussion, Mr. Hooper had raised some other. So we're quite happy for you to have a slightly bigger picture. But all I'd ask, if you're happy to accept our point, is that you've got the two respective positions. And if you need any clarification, that's fine. But that at least puts our position and the appellant's. So on that, on the relationship between Brandon and St Phillips Limited, we've been given information on that. I'm not taking that further. The third matter, the discount for the affordable housing, we did write straight back. We just wanted to understand we understood that was about the rented properties rather than the shared ownership, which would also, as we understand it, going to the registered housing provider, at least in the first instance. So we sought clarification. Does that apply to both? And I'm not. We didn't get an answer to that. So that's all that's outstanding from us.
Okay, then I think that's something we'll cover when we go through the 106 agreement anyway, in terms of the discount. So I think we can come back to it.
That's fine, Madam. It's just to articulate the.
No, that's fine. I understand the point you're making. Yes, the response here related to affordable rent levels being 80% of market rent, wasn't it? Yeah.
Oh, up to 80%, I think, yes.
Yeah, but we'll come back to it. That's fine. Yeah, no problem. Okay. Right. Now, I haven't yet received any closing submissions from Dr. Bowes from yesterday.
I've just received them, and they've been copied to your case officer.
Right, that's fine. I'm sure.
I'm quite sure they'll be on their way
to me this morning.
And my learned friend Mr. Humphreys and my learned friend Mr. Goatley were on the distribution list as well. So
So hopefully everybody has got it this morning. It'll be on its way, hopefully.
It pinged into my inbox at 9:27.
Right. Okay. Right. Well, hopefully it's all
but
right.
while we're all waiting for that, we have a very short factual document which we would like to hand into you, which we circulated to the parties last week. It is correcting something that was said in evidence by our consultants,
Right.
who may or may not have been aware of the full position.
Okay.
And we just want to make sure that you have the correct position rather than an incorrect position.
That's fine. What does it relate to, Mr.
It relates to 3G pitch delivery. You'll recall that the evidence before us is that there is an outstanding need at present for one 3G pitch.
Yeah.
That does not change.
Right.
But the evidence before you is also that there have been no pitches delivered in the borough since 2015.
Yes, that's right.
That has changed because
Okay.
there have been 2 pitches delivered in the borough, which our consultants were not aware of when they gave their evidence. And so the correct position is there is an outstanding need, as there always was in the evidence.
Yeah.
That hasn't changed. What's changed is what's been going on since 2015.
Right, okay, that's fine. And all parties have seen that, yes?
Yes.
Right, okay. So are you going to hand that to me
Yes,
now?
if we can. And
That's fine.
we'll then give it a CD number.
Yes. That's
The note you got sent by
Thank you.
last week has already been given a CD number.
Yes, okay. Right, okay, thank you. I also received yesterday an email on behalf of you, Mr. Humphreys, in relation to your closings, making reference to some additional case law that I believe we haven't seen before.
No, I referred to certainly one of the cases in my own.
Right, okay. I just wanted to be clear on whether this is new evidence that we haven't...
No, but case law isn't new evidence.
well, we haven't seen it yet, have we?
Well, it's no, madam. It's perfect. I've let my known friends have a copy of it. Which
Yes,
is
I noticed
usual.
it was circulated to all parties.
Yes,
Yeah.
and it's perfectly normal to refer to legal submissions
Yes.
in closing, and to circulate them beforehand is sensible.
Yes.
And
So
courteous.
everyone's aware. Yeah.
So I don't. It's
Okay.
I don't. I've indicated in the email what it concerns to a concerned Greenbelt. I don't anticipate it's at all controversial. It's
Okay.
it's simply to assist you.
Right. Okay. Yeah. I do have that anyway in the full
Yeah.
full case, full judgments as well. Yeah.
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 Thank you.
Okay. All right. Thank you. Right. Anything further from anybody before we kick off this morning with our roundtable on obligation and conditions? We're all content? Right. Good. Okay. So, what I want to start off with is looking at the obligation itself. Now, the way I intend to do this is to go through the sub-compliance statements. We have 2 of those, one from Rugby Council and one from the County Council. So I'm going to start with Rugby Borough Council seal statement and just go through that in terms of the various requirements in the 106 agreement. But before I do that, I'll just give parties the opportunity, if they wish to do so, to give some general comments about the 106 and its structure. Anything anybody wants to put before me now before we go into that detail? No?
So this is about 106.
Yes.
Yeah. I think we have got a number of points, but perhaps it will
We'll
become...
probably cover them as we go through, I suspect.
Yeah, I think
Yeah.
so. Just to say, we obviously, it was 2 months ago we adjourned. On Sunday night, Mr. Carter received, I didn't see it till the Monday, yesterday, this Monday, a revised draft, I think.
Yes, I've got that as well. Yeah.
And I think it might be helpful at some point just to have some explanation by the main parties as to what's being proposed, what differences are and what the theme is. But it may be that will come out as we go through it.
I think it'll probably come out as we go through, to be honest.
That's fine.
Yes, I have got that. I received that. I can't remember when I received it. It might have been Sunday myself, actually, when I got it. I can't remember. But I have seen it, and there are some changes to that.
Yes.
But I think we'll probably address them as we go through.
No, that's fine.
Hopefully, if that's all right.
No, sorry, man, because you said,
No,
are there any Any overarching
Anything about
matters?
overarching structure or the comments anybody wanted to make, that's all I was suggesting. Right, that's fine. Okay then, so. So we'll start off with Rugby Council's still statement, and just to go through the various elements of that and the requirements. So first of all, play and open space. And the requirements for various contributions within that, various amounts. Can I ask the appellant, do you wish to comment on this, particularly those changes in relation to not just the contributions, but at various points within the inquiry, there was reference to a dowry, which basically is a contribution for the pitch and its establishment. Now, that has changed. Originally, that was a contribution of £100,000 in the original 106s. That has now changed. So perhaps you could address that point for me, please.
Yes, ma'am. So you're quite right. At the point that the inquiry closed, we had a dowry of £100,000, the intention of which was, as John Eady from KKP explained, it was a fund that could be drawn upon by the operator of the pavilion to cover operational costs, particularly in the early years where the business plan showed that there would be a loss. Discussion at the inquiry focused on the risk of the operator of that pavilion going into administration. Yeah. Immediately following the inquiry, we advanced insertion of a clause to the 106 suggesting the local planning authority had step-in rights in the eventuality that the operators of that pavilion went into administration. Obviously, that is aside from the clause that is in there enabling the offer of that pitch on completion to the local authority. So this is an additional safeguard. The authority have reverted to say that is not something they would be interested in taking forward because of the uncertainty around taking on cost at that stage and recovery of cost in it from a company who's in administration. And therefore, the latest revision that has been put forward takes the contribution, and we effectively split that into two. There is now the kind of the dowry and the maintenance fund is a fund that can be drawn upon by the operator in those early years, and we have split that as a £60,000 of the £100,000, and then there is an additional sum that is held back in the eventuality that that could be drawn upon by any other party coming in the event that the operator goes into administration. That split and the insertion of that is on the basis that KKP advises that it is highly unlikely that the operator would go into administration. As we advance at the inquiry, there is a very robust business plan in place. That dowry is in effect covering the potential shortfall, or there will be a shortfall in those early years, and ongoing maintenance for a period to be doubly safe that the administration is very much limited. But we have offered that additional 40k split now as a step in. Yes.
The default sum that's itemised in the revised 106 agreement that we have before us now.
Yeah, we've also, in terms of the I guess the oversight on those funds being drawn upon, obviously the management company, we have inserted a suggestion that the local authority could sit on that management company board. So there is oversight. If they don't step in on day one and take on the pitch, which is obviously an option that is available to them, they have the opportunity to sit on the board of that management company to give overall oversight to make sure that the funds, in line with the terms that are set out in the draft agreement, are being spent appropriately.
Council or the Rule 6 party want to comment on those arrangements?
Yes, so in terms of the dowry payment, we understand that obviously it was the £100,000 first, and now it's been split into two. We're not quite sure how the 40 and the 60 has come about in terms of the split.
For those figures, you mean?
Yes.
Yeah. Why 60 and 40, not
yes,
50-50 or whatever?
Exactly. So the 60 would obviously be for the management company to draw on in terms of the forward funding, and we're happy for that to be in an escrow account. The 40 itself, though, it doesn't seem like that would be a significant amount of money for the council to draw on in terms of maintenance. So in terms of Sport England figures, maintenance for a pitch of this specification, an annual amount would be just under £6,000.
So that 40,000, Mr. Hooper, how long is that intended to support the council's maintenance of the pitch going forward? How has the 60-40 been arrived at?
Well, if I start with the 100,000, so the 100,000 figure that was in there initially was a figure that's been provided to us by KKP on the basis of their experience of a traditional dowry. The split and the balance of that split is that we maintain the position that it is highly unlikely that the operator go into administration. The risk is in those early years, as the business plan has identified, and therefore the balance of those payments is in the fund that can be readily drawn upon. The 40,000, the lesser amount, is as a last resort, and therefore in the eventuality that the council or somebody else, another operator, was found to come in and take forward the pitch, the pavilion, that 40 is effectively a bonus. You know, the facilities are there, that 60 has been drawn upon, and it's been maintenance and ongoing provision has been in accordance with the requirements as set out by the ManCo, which the authority are able to sit upon. So we feel that's an appropriate split.
The principal difficulty is this: if the time arrives where it's necessary for the council or somebody else to step in, that means that the management company has failed, and it has not proved possible to run it successfully by the management company. Now, in those circumstances, to say to the council, well, you step in and here is just under 6 years' worth of maintenance money, you see if you can make it work where we failed. That's not going to happen. If the management company fails, so will the council with what's on the table.
There is, yeah, except there's a likelihood, but would the council then take steps to try and seek another provider rather than operating it themselves? I mean, they would then have 6 years to try and look at an alternative solution.
I'm also being advised that I should explain, behind me, you haven't met Sarah Chapman yet. She's my instructing solicitor. Yes.
Thank you. The other concern we have around the terms of how it's set out in the Section 106 agreement is, whilst we understand the escrow provision for the management company operating costs for them to draw on it and the arrangements set up between the developer and the management company, our concern would be that the default sum, if that was put into an escrow account that was set up by the appellant, that then the appellant disappeared and the operating company has failed, is our ability to then easily access that money or where that money has gone or who else has calls on it. So in terms of that being there as a safeguard for the council to call on in the event of everything else failing, irrespective of what sum we might come to for that, the council would be a lot more comfortable and a lot safer and better protected if that was presented in the form of a bond rather than an escrow account.
Okay. Is there anything else that you'd like to see changed besides the bond arrangements? Is there any other aspects of it that you feel would be better from your perspective?
We would just question, in terms of the maintenance fee, whether that would include the sinking fund as well, because obviously that's a greater amount of money in a round of, I think Sport England quotes it as just under 30,000 a year, and for the council to find £30,000 a year for a sinking fund that's not included within the provisions of Section 106 is a substantial amount of money.
Goatley then?
One suggestion for overcoming that, because a concern certainly Ms Chapman ventilated, was what happens if the management company goes and the ability to access that money. The alternative would be, and the reason for this is practical rather than legal, because there are difficulties setting up bonds, and I hear the observations made in respect of the escrow account as to whether or not there would be a beneficiary of that, would be for that to be a ring-fenced sum in a ring-fenced account, so the council said if not called upon within X years, then that would be then returned. That would be an alternative mechanism. Would that overcome, as a matter of principle, that concern? Thank you. Next awkward subject is how much for those purposes. The suggestion at the moment is, and I don't understand it to have been particularly problematic as a sum to deal with it, is £40,000. If that £40,000 was put in a ring-fenced account, would that satisfy the council's concerns?
So I think, and this is the point that my colleague was just making, is we're not, the trouble we have is at what point are we thinking the management company might fail? Because whilst I appreciate what you're saying about the risk of it failing early is unlikely, in the event that it does and the council has 9 years of which to produce this, the 40,000 is not enough. And it's also the point that Ms Casey was just making about the difference between the Sports England advice about the sinking fund, because I understand it's recarpeted after 10 years, which would be, if the management company has failed, that's going to come to the council, and where do we find the money for that, versus also the annual maintenance fee. So I don't know whether the number is correct, and that's something my colleague would speak to. But what I would say is if we were going to put a ring-fenced amount in the council to hold, subject to when it was needed, I would be content for that also to be tapered. So for each year that the management company succeeds, some of that money could be returned rather than the whole amount being held by the council.
Okay. 2 points. First of all, initial sum and the duration of the taper. Do you have a view in respect of that?
So I would say that in line with our other open space provisions, sports provisions, and how we usually look at maintenance, we're looking at a 10-year period, because that's usually the period we ask for a commuted sum for. So that would seem to me to be reasonable. So
crudely 10%.
And then as to the actual figures in terms of maintenance and sinking fund, I'm going to have to pass to Ella for that.
So annual maintenance, Sport England sets out for a pitch of this specification to be £5,850, and an annual sinking fund would be £29,250.
So just to be clear on the sinking fund, so the sinking fund was built into the business plan. So the costs associated with pitch, because it is a known entity.
Yes, but that would be, so the management company would deal with the sinking fund, wouldn't they? But if they disappear, then it would fall to the council to have to...
Assumably, if the management company goes bust, then it has run out of money, and therefore the sinking fund is in fact zero.
Just to be clear, by the time the council would take over, it would wish to have a sinking fund, circa 29,000 for the purposes of taking a datum figure now.
Yes, it would need to be able to replace the carpet at the appropriate time. And therefore, if, for example, the management company went bust after 9 years and the carpet was due to be replaced the following year, then they would need pretty much the whole cost of replacing the carpet.
Do you want to park this and have some discussion?
In terms of just trying to break this down, first of all, I'm going to call them sums A and B. Sum A is the sinking fund. Hearing what the council have said in respect of that, sum A, the sinking fund, that could be effectively one ring-fenced, and when I say ring-fenced, put into an interest-bearing account, and then essentially taking the full 10-year period, because I think after 10 years, either the management company will have succeeded or will have failed, then all of the corpus of that Fund A, if the management company has not failed, would then revert to the developer. Sum B, which is the amount in terms of the maintenance, that would be, I would suggest, £40,000 to take account of what's been discussed, and that would then be tapered in the manner that Ms Chapman spoke of a moment ago. Effectively, again, it would be interest-bearing, but 10% would then be remitted. Would that mechanism work?
As a matter of principle, that the maintenance sum tapering and the sinking fund accruing is the right way to do it. If it's 10 years, then the maintenance is not 40k, it's 58,500. And then the sinking fund accruing is at 29,250 a year.
No, not a year. It's a sinking fund. So it sits there. So
That's the annual.
It's a single lump sum.
No.
No, so the Sport England guidance says that every year 2.5% of the capital cost should be put into a sinking fund, which is 29,250 annually. So a 10-year period would be just under 300,000.
And that's to enable you to redo the carpet. Now, if after 10 years the management company is still going and the carpet comes up for renewal, then that money in the sinking fund can be used to relay the carpet by the management company. But it's ring-fenced in case the management company fails before the 10-year period. So it doesn't go back to the developer, it just stays with the management company.
Management company is operating in accordance with the business plan. It doesn't need it. So it does not go to the...
No, but the management company accounts say, we are allowing for a sinking fund for the carpet. Well, what we're saying is that sinking fund needs to be ring-fenced so that if the management company fails, the management company can't have misspent that sinking fund.
Well, that's effectively... Okay, there are a series of things which are bound up in that. The purpose of this is to allow a mechanism for step-in for the council. Going back to this is a safety net provision.
It is.
The safety net provision is in circumstances of step-in that the council is not put effectively to unnecessary public expense in those circumstances.
Correct.
It's not with a view to effectively micromanaging the management company in terms of holding on to the funds. So there are two distinct streams that are going on there, and I think we have to be careful not to conflate them. So far as the first element is concerned, it's what is necessary by way of that element of the sinking fund. It seems to me the sinking fund, if it is to be a substantial figure, and I'm going to have to take instructions on that, that itself should be tapered. Because again, if the sinking fund is being applied properly and the business is operating properly, then the money should not be tied up for a prolonged period of time. Because the amounts that we're otherwise dealing with are exceptionally large on top of what is otherwise an exceptionally large contribution.
But if the council has to step in year 9...
Then it should have...
It is faced with a very large bill in year 10. If the council has to step in year 11 and the carpet has just been replaced, happy days. If the council steps in year 11 but the council was not replaced in year 10, the council is faced with a very large bill.
The very large bill is not a 300,000 bill.
Well,
if the sinking fund has been applied year on year...
No, the sinking fund is essentially a savings scheme against the day when the very large bill needs to be paid. Essentially, it's not being accrued just for the sake of accruing. It's with a view of accrual on an annual basis in order to be able to provide for maintenance as and when it arises. no, the maintenance provides for maintenance. The sinking fund provides for the capital works necessary periodically to relay the carpet.
Well, okay, whether you say renewal or replacement, it's the same point.
Yeah.
Right, can I just sort of interject here? We seem to be not really going around in circles, but this is taking up quite a lot of inquiry time, and it's something that is important to resolve, but I'm just wondering whether it's something that's better to be dealt with separately out with this morning and for parties to come to an agreement on this.
I think that's probably right. I think as all the principal participants are here for that may present an opportunity, and I don't wish to needlessly prolong time, but it strikes me that it may be worthwhile having a short period of time to be very clear upon the Council's objectives and concerns and those relating to the appellant by reference to the matters that have otherwise been discussed. But
We'll enable all parties to seek instructions from their individual clients as well, rather than continuing this debate now.
I understand that, ma'am. Can I?
What I would like to do, I don't know about what parties feel, is to continue looking at the 106 agreement and then having an adjournment, and you can come back, have a slightly longer adjournment than normal and just address the open space issue. Would that work for you?
I think that would work very well, ma'am.
Yeah. Okay. So we'll just park it for now and continue looking at other aspects of the 106 then. Okay. Thank you.
Ma'am, just in relation to the sports pitch, can we just briefly touch on the community use agreement?
Yeah, that's fine.
So I have spoke to the appellant and the duration and term has been removed, but they're happy for that to be reinserted into the community use definition. Also, we would like some sort of fixed pricing schedule in terms of the pitch, so that the costs associated with the pitch can't be significantly increased for the community. And then the final thing is just we would like to control the minimum number of hours in terms of the times that the community could use it. So I'm not sure if the appellant has a figure as to the number that they're currently proposing that would be available for the community.
Would the hours of use not be in effect determined to an extent by the proposed condition in terms of the hours of lighting? So that's the period which the use can take place. So therefore, that's the maximum use the pitch can be put towards.
Yeah, so that's the total number of hours, but obviously the management company would be able to choose how many hours they would lease it privately to other clubs. But in terms of use for the community, that's what we're looking to control.
What's the council done on other pitches of this nature? What's your normal requirement, if there is one?
We don't have one.
No precedent?
No, that's why we're seeking the appellant to kind of put a figure forward in terms of what would be reasonable.
On the coloured chart that's in the evidence, this sort of the users, you'll recall that the chart that's set out that indicates the types of user and when that might happen. As an example, there is a split which shows some hours for the community use and some hours for the main operator, Sky Blues, and the community, or whoever it is. So that's all we're saying. Perhaps they could come
Do you have a figure in mind?
Well, we don't really have a precedent for it. It's just we've had other cases where the sports pitch doesn't have, well, it has a very limited amount of community hours, so that's what we're trying to avoid here.
I understand what you're trying to avoid. I just wonder whether you have an indication for the appellant of your minimum, shall we say, put it that way.
What should we mention? Park that and have the discussion.
See if that's helping as well.
Can I just say, there's the community use definition, there's the number of community hours. I think there was a point in between, which I'm afraid I missed. Beg your pardon.
The fixed pricing
schedule. Again, I assume you have no precedent for that in other 3G pitches or community use facilities that you've got in the borough?
No, just bad experience.
Okay, all right. Right, I understand. Okay, thank you. Okay, so is that everything on the sports pitch and the arrangements around that? Right, okay. Mr. Humphrey, is there anything from your perspective?
In relation
to the sports pitch, that is?
No, Madam, you know our evidence. We have, we support what the council said. We have
okay, that's fine, just checking. Okay, so in terms of the open space contribution, that's for the open space topologies, some of 152,320. I'm content with that in terms of the policy support for it and how it's calculated. So I'm going to assume that nobody has any particular views in relation to that. That's an agreed amount. Yes? Can we move on to affordable housing then? In the agreement. I mean, a lot of this in the 106 is fairly standard in terms of the requirements and the safeguards within that, which I'm sure everybody is aware of. But I know the Rule 6 party want to just ask some questions in relation to discounts. Now, the agreement allows for 80% of market rent discount for affordable rent units. The question was around shared ownership, wasn't it? Perhaps the appellant could just advise what the intention is and what the 106 agreement provides for.
Yeah, thank you, Mel. Obviously, just taking a step back, obviously there is provision within the agreement for a cascade mechanism in terms of the actual precise split of the kind of the nature of the affordable to be agreed with the LPA. So there is a cascade through the agreement. In terms of that, in terms of the discounts, sorry, just bear with me. So as we have the definitions on page 16, in terms of the shared ownership dwellings, in terms of the definition, which, as you say, Malm, is a fairly standard definition in our experience, the definition within that being less than 75% in terms of the initial percentage, in terms of shared ownership. And then, again, as per the note, social rent dwellings, again, being offered via an affordable housing provider with an insured tenancy. Again, we see that as a pretty standard definition. And then in terms of the actual, so as we've discussed at the inquiry, 20% of the dwellings across the development, again, as per the agreement. And then the definition in terms of tenure and bind is in there. The split, as proposed, is 56% to be social rent and 44 affordable dwellings in shared ownership. But as I say, the provision is made that that split is to be agreed with the local planning authority.
So can I ask the council, presumably your housing team, are they satisfied with the requirements in the 106? It's your normal position, is that right?
Yes, there are standard clauses and they're satisfied with that.
Right, okay, thank you. Mr Humphreys?
So, as I understand it then, the properties will be provided to a to a housing provider. Will be 80% of market value in respect of social rent and 75% in terms of shared ownership. That will be the discounted market value when it's given to the registered provider. What we're concerned, if we remind ourselves, obviously we have a tenure split of 56 to 44 down from the original 86-14. Are we actually going to have that provided? The way the agreement is structured at the moment in terms of clause 6 on page 19 and 20 in particular is that there's a 6-month period from the commencement of the development on each residential phase. That's no later than 6 months from that commencement of development on each residential phase. That's referred to as the long stop. It's going to be marketing of the affordable dwellings to be managed by an affordable housing provider. at the same time, 6.2, if that hasn't happened by the long stop date, then we're going to go to a discount. Sorry, just staying with 6.1. At the same time as marketing to the affordable housing provider, 6.1.2, there's also marketing potentially as discount market dwellings, and at the same time, 6.1.3, marketing as private intermediate dwellings. So it's not immediately clear to me how the cascade works. I assume that one has to try the affordable housing first, but it's not very clearly written in my respectful submission. And then one goes to discount market dwellings, which of course discount market would not be involving a registered housing provider. So it's at that point, that's why the percentage is so important, and also whether it's actually going to eventuate. That's
DMV is a form of affordable housing in line with the definition in the glossary of the framework, isn't it?
What is it? Sorry, I just missed
discounted market value. Discounted market units
but,
are affordable, type of affordable.
But what we're dealing with here is the need that's been identified by the SHMA and by the HEDNA is about social rent, and it's about shared ownership. It's not about discount market sales. And so if we just slide towards that, we miss the whole planning point.
I understand what you're saying, yes, I completely understand. But I'm sure you're aware that the normal practice in a 106 agreement is to start off with that as the baseline. And then if the scheme is marketed and for whatever reason those units aren't taken up by an affordable housing provider, there are then a series of measures to look at other options or maybe a revised scheme just to ensure those units are provided as affordable units, but maybe under a different tenure.
It's not entirely clearly worded for that, but I understand the principle. I understand the principle. But one remembers that the 56-44 split came from the appellants, not from the councils that own evidence. It was their split.
Right.
So that, and then there's agreement, then there can be agreement with the council for that split to change. And then if that still doesn't do it, then there can be agreement that actually you go to the discount market. I think that's probably the way it is. So we're just highlighting, I appreciate wanting to have a cascade seat, but it's important to see that it could very easily go straight to discount marketing, because that is what, if one remembers, we've had evidence as to this, significant lack of demand for social rent. So it's effectively flagging up, this could be discount marketing. And the CBRE advice on the viability was on discount marketing. They're assuming it's going to discount market sales. It will never get to social rent or shared ownership.
I understand what you're saying. Can I ask the council, do you want to address that point? If this is something that your housing team are content with, and it is your normal process, should we say, in terms of cascading, well, I assume it is, in terms of cascading through the system, as it were, if depending on circumstances and how things progress, do you want to just address some of the points Mr Humphreys made to give him some reassurance?
I'm happy to speak to this. So this is our standard drafting, and I appreciate the points you're making, Mr Humphreys. The way that it's drafted is, our standard drafting for essentially all affordable housing situations, and the way that 6.1 operates is that you could only market them as discount market dwellings or private intermediate dwellings if they were in the initial tenure mix, which in this instance they're not. So only really 6.1.1 would bite, and they would have to be marketed for affordable housing providers as the social rented units initially, and only if that wasn't taken up by the registered providers in this area, which in our experience recently has been unlikely because there is a demand for it there, only then would you be able to go to 6.2 and revise the affordable tenure mix and look to do something other than those initial social rented dwellings. So we've used this drafting on a number of our Section 106s, and it works very well with our registered providers in practice. And a lot of it has been drafted also to take account of the registered providers, mortgage companies and financiers and lenders to make sure that they are market appropriate for them as well. So I hope that helps.
I'm grateful I'm grateful for clarification. I can only go on the evidence we've heard at this inquiry. So that's what thank you.
Thank you. So anything else on the affordable housing clause? Yeah.
Thank you, Mark. I mean, I think that from the SCS's point of view, our concerns in terms of comments on Section 106 and the draft conditions, are on the basis of we would hope that the scheme that is actually developed is the scheme that we've been discussing throughout this appeal, and not some other significant variation from it. So specifically in relation to that last point, and it's the value of the discount that will be offered to the registered provider for the provision of the social rented dwellings. Because my reading of the Section 106 is that when you get to the end of it, there has to be a 65% discount offered. But I think it's unclear whether that 65% discount would be offered at the outset to the registered provider to actually provide the scheme that's in the proposal that we're considering. Thank you.
Well, it reads clear to me, but I think the council have already expressed the view that this is a standard approach in other 106s, and it works well for them with other RPs. I'm happy with it as worded. Does the council want to comment on that? No? Okay, all right. We'll move on to some of the other provisions. We discussed yesterday the contribution to the NHS Trust, so I don't intend to look at that today. That's the 133,000. We've had enough discussion on that yesterday. The other element is a sum of 82,000 towards additional capacity in healthcare facilities. My main query in relation to this is where this money would potentially be spent, because what the 106 is suggesting is that it is to serve that area. Now, I think it's CD 9.18 makes reference to 6 possible medical practices that this money could be used. Do we have any further confirmation of which GP surgery or facility? Can this be tightened up at all so that it's clear how these monies will be spent, and is it actually related to the development and the future occupants? Can I ask the council for review?
Yes, so CD 9.18 does set out the 6 surgeries that are in that area and within the catchment of the development. At this stage, it's not expressly said which surgery would have an extension to facilitate this development. So yeah, the Section 106, normally we just we put the relevant surgery names within it, and then there's the option to spend it. It's normally a couple, but obviously in this instance they have stated 6 practices.
Not named in the agreement, are they?
No, we can list them in the agreement.
I think it might be helpful if they are, just for clarity, and then
Yes,
it's clear that it does relate to those surgeries that are effectively the ones that would be used by future occupants, future residents.
We can list those.
Okay, thank you. Right, we looked at sports provision. But I think that's everything in the council's SIL compliance statement that we need to address. I want to look at the contributions requested by the county council, in particular the highways contributions. There are a number of those. Traffic regulation order, £6,000, which is effectively towards traffic calming. Then there's road safety initiatives, some are £50 per dwelling, totalling 6,200. Is that necessary, is the question. Can I ask the council?
Yes, so the County Council have set out their policies in relation to road safety initiatives. Within the document, sorry, I'm just reading it. Yeah, it's in terms of the SIL tests, it relates to the development as it's a per dwelling figure.
To the development in terms of the number of dwellings, but does it relate in terms of what is that will actually be done? Will it benefit those future residents?
So in terms of the policies that the county have stated, in terms of working with schools and the development, it will be a balanced community that is on that site. So there will be school children and quite a significant number. And in terms of the initiatives that they have, it's all about the safety of young children at school and making them aware of those initiatives and making them partake in that. The same for young drivers and passengers.
Any comments from the appellant? You're happy to include this contribution?
Yes, ma'am.
Yeah, okay. All right, I'll take on board your comments. There is also then a sustainable travel contribution of £1,240, £10 per dwelling, which is basically, I think, the dwelling pack, isn't it?
Yes,
which is very often seen. And again, that's supported by various policies in the local transport plan and to support various transport awareness campaigns. We then move on to education, I think. That's the 1.2 million in total. That's divided into different elements of the education system: early years, primary, secondary, post-16 and SEND. Now, in terms of primary and early years, I think I'm content with that. I just want to clarify in terms of secondary schools and the SEND contribution, how does that relate directly to the development? How is that likely to be used?
So the need is calculated on the same basis as the early years in the primary, but obviously different inputs based on the secondary and post-16 and the SEND. So it does relate directly to the development. In terms of where it would be spent, as I explained yesterday, we do have an issue in the north of the borough that we're aware of. There's not a secondary school in that area, and we are working with the Education Authority in terms of what we can do in that area and what the solution is. So currently in Section 106 agreements, for this type of provision, we're not being as specific as with other primary and early years provision, because we can't be. The solution isn't known as such, but it is felt that in terms of secondary, a lot of school students do travel further, so they would possibly go to the Rugby urban area, or the catchment is a wider area. So in terms of it currently being set out to be used within the borough, we do feel that it does meet the SIL compliance tests.
Looking at the actual clauses and definitions in the agreement, so the secondary education contribution makes reference to Bilton School, so that gives some clarity there. It's the post-16, I think, and the SEND education contribution is a little bit vague, shall we say, but it does clearly say arising in connection with the development. So it's a question of demonstrating that that is the case, that it does arise from the development and is used in that way. I think SEND is a little bit of a, not really a difficult one, but it's harder to demonstrate when you're monitoring that 106 to ensure that those monies have been spent to facilitate and to support future occupants. It's how it relates to that development. Have you used this before? Is this something that you've experienced with other schemes?
Yes, we've asked for this contribution before,
Yeah.
And the county, obviously, they have to have their infrastructure funding statement, so they do report on contributions as such of this nature.
Okay, right. Okay, thank you. We'll leave that there. Anything from the appellant? No, you are content? Okay, so the other contributions requested relate to public rights of way. They're improvements within 1.5 mile radius of the site for dog walkers effectively. So that clearly relates to the development. Monitoring fee request as well, which the PPD does allow for. Now, there are, from my recollection, there are at least two separate monitoring requests, one from the County Council for their monitoring of the agreement, and then separate monitoring requests for the Council. Now, there are 3 requests from the Council, aren't there, to monitor the different aspects. So it's basically 4 lots of £500 effectively, I think. So is it normal practice to have a separate request for different elements of the agreement from the Council rather than just one global sum for their overall monitoring?
Yes, we have. It depends. So our monitoring fees are set out, but it depends on the type of obligation and the number of them, how they're monitored.
Right. So where are your fees set out, please?
I think they're on our website. Yeah, they're on our website.
Oh, right, okay. Right. Okay, thank you. I think that's everything. Yes, this seal statement then goes on to demonstrate the calculations for education for the rights of way, which is helpful just to give that background. So that's good. I think that's all I need to go through, I think, this morning. Is anything from any other party? Yeah, Mr. Humphreys.
Just one matter, please, Madam. In the section 106, the draft on page 2 in the definition sections, commencement of development is defined as meaning carrying out a material operation in the usual way, but for no other operations consisting of, and little a is site clearance, by which I assume that covers demolition. And obviously we have concerns about that because if this development is to go ahead, it should proceed to, if it is granted permission, it should proceed to deliver the benefits as put forward by the appellant. What we don't want is a hiatus of demolition taking place but not triggering anything, triggering the start of the development and therefore this. And then a long period whereby, with a local plan review in process, it's then said, oh, well, we've demolished it, it's gone now, or the sports pitch turns out not to be viable, so we'd like to use that area now. In other words, if to deliver the...
Always that risk, Mr. Humphreys.
No, I know. But if in my respectful submission, obviously it's a matter, we have an agreement in that form, but there'll be, I just mentioned the consequences now, because in terms of delivery of the benefits which are asserted, and it comes on, when we come to conditions, you'll see that the last of the reserve matters doesn't have to be put in for up to 3 years. And excluded again from the development is the demolition. So it's all of a piece there. I just mentioned that simply for you to be aware of. That's all.
So are you suggesting an amendment to the 106, or is it just need for me to be aware of the potential consequence?
Well, it's a matter for the appellant and the council. We would have requested, but obviously we can't impose, we would have requested that commencement of development doesn't includes demolition would be part of the commencement.
Demolition not to be part of commencement?
No, is part of it.
Yes, that's what I thought you said, yeah.
Sorry, yes.
So I suppose whether site clearance includes demolition or not?
Well, I imagine it. I've assumed it.
Well, one would think so. Any clarity, please?
Yes, I can speak to this. So site clearance we would anticipate including demolition because that's how you would clear the site. We wouldn't ordinarily amend our section 106 definition of commencement given the covenants that are in place around returning contributions and such like that might be triggered by commencement. We want to mitigate the impacts of the development as it's built. So if the site is cleared and nothing further happens, there's nothing to mitigate, so we wouldn't want to collect all the money in and then be having to return it. So this is our standard position, and we wouldn't be minded to amend that on this instance.
I take the point. Thank you. Right. Anything further? Yes. Okay.
Just a quick point, Ma'am. When I was reading through the Section 106 agreement, I couldn't see any reference to the pavilion at all. So,
Right.
Given that the pavilion contains the changing room, there's obviously a relationship between the two. So, you know, the agreement
Yes.
talks about transfer to the council or management company or otherwise. So why isn't the pavilion included?
Yes. That's something I picked up on actually, because the pavilion is covered by conditions, isn't it? Right, have you got that?
Yes. Includes the pavilion and associated car parking. So it's a whole package.
Yeah. Okay, thank you. Okay, I think that's everything I need for today in terms of the 106 agreement. Can I just ask, do you wish to have a break now, or shall we continue with conditions and then have a break? I'm in your hands, really. I'm happy to continue to go through conditions then break.
Yeah, we're happy to do that.
Yeah.
Break now or break later?
Yes, that's the question.
But do conditions.
Do conditions and break? Yeah, we'll do that. Okay. Right. Change bits of paper.
I'm still working to core document 14.4, which I'm told is still the document to work to.
I'm working to a similar doc. I'm not sure what CD number. I've printed it off, but it's the one dated 13th of October 23. Yep. That's the one I'm looking at.
Okay.
Right. So in terms of simplicity, I'm trying to get through this reasonably quickly, as there are a number of conditions. There are 46 in total. What I'll do, I think, is probably lead on this myself and go through it reasonably quickly, rather than asking the council to individually go through and explain them all and what have you. I think we can do it probably a bit quicker doing it that way. So, just as a general point, first of all, there are a number of pre-commencement conditions within this document which need to be agreed by the appellant. I could do with that in writing, please. Just an email will be fine.
Yes, ma'am. I think we did provide that prior to the inquiry, but we can re-provide that, ma'am.
If it's referenced somewhere else in your statement, then just give me the reference. It's fine.
Okay.
Just so I'm clear that you do have agreement to it, that's all.
Okay.
That's fine. Okay, thank you. Right, so condition 1, 2 and 3 are basically the standard conditions in relation to an outline application. In this matter, landscaping being the reserved element. So those are fairly standard, so I don't have any particular comments in relation to those. Can I just say, if any other party wants to say anything, just pipe up as I'm going through them, because that's probably the easiest way. Mr Humphreys?
Yes, Madam, just to point out, condition 1, there's the first line excluding demolition. Condition 2, the third line, that's 3 years for the final reserved matters to be put in, I think. The points I've made before.
Yes. Okay. All right. Thank you. Condition 4 requires the submission of reserved matter relating to landscape, a scheme which details the semi-mature oak tree planting to be submitted, then the scheme completed in accordance with that. Does that need a maintenance clause or a retention clause, or is that covered by condition 27?
That's covered by the separate condition.
Right, that's what I thought. That's fine. Okay. Number 5 sets out the drawings to be approved. I know that has been amended, so I assume that's the amended version with the appropriate revision references for the individual documents. Number 6 restricts the number of dwellings to 124, which is what's being applied for.
Just a small point on that. Saying no more than 124, should it not say shall consist of 124? They're applying for 124.
Yes, I suppose they could
But
construct fewer.
well,
It's just setting the maximum, basically, isn't it?
Okay.
Yeah. Okay. Okay, thank you. I'll have a look at it anyway, if I need to. Number 7 looks at the sports pavilion and requests details of siting, design, materials, layout of the car park. It shall be constructed in accordance with the approved details. There's 2 inns in there. That's just a typo. That's no problem. We can resolve that. We're all content with that. Number 8 then requires a minimum floor area, 150 square metres for the pavilion. Number 9 then requires a sports pitch to be constructed and available for use for the occupation of 50% of the dwellings. Yeah.
Ma'am, on number 9, I was just going to make the point that before occupation of 50% of the dwellings, that compares with one occupation of the first dwelling for the sports pitches, I believe in the section 106. So if we're talking about a 4-year construction period, doesn't that imply up to 2 years with no changing facilities for the sports pitch?
Yes, that's something I want to come on to, actually, because I think there is an inconsistency between when things are being required to be provided, and I think it might come out when we go on to look at other conditions. But I take your point on that, because I think there is an issue there, potentially. Right, okay. Number 10 is basically a materials condition requiring the submission of samples of facing bricks, roof materials, external surfaces of buildings, which is a standard condition. Number 11 looks at details for walls, fences, railings and gates to be submitted and approved. Do we need a retention clause within that?
Yes.
Yeah. Ms. Hooper?
Yes, ma'am.
Yeah, okay. Right, number 12 looks at air quality mitigation requirements. This isn't really something we've addressed during the inquiry, and I just want to understand, what's the council's expectation here? What are you actually looking for?
So it's normally the details in relation to the new boilers and whatever else was detailed within the committee report. So whatever they've set out that will increase air quality, and on this site, that's the details required within this condition.
Right. Is that condition sufficiently precise then? It looks at on-site measures to be incorporated within the developments to meet the air quality mitigation requirements of policy HS5. So what does HS5 require?
That there'll be no detrimental air quality impact. So for new developments, there has to be a neutral impact on air quality.
Right. Is that necessary in this case? Is it covered by other regulation? If you're looking at boiler emissions.
Let me just double check what they're proposing. Give me one.
Ma'am, I think it also covers things like electrical vehicles. So I think it's general promotion of
yes,
initiatives.
we have another condition about EV charging points, don't we? Provision
we
of.
do, yeah, in terms of the charging points.
Yeah.
I think this is more in relation to air quality itself directly.
Right.
But we do agree it's not a point that's been a massive contention at the inquiry.
Is it something you're prepared to accept?
It is, on the basis that, as Ms Casey has set out, there are a number of initiatives that have been inbuilt into the scheme, into the design of the scheme, partly as required by other elements, other conditions and other requirements.
Yeah.
So the electrical vehicle charging, the gas boilers,
Yeah,
in
they
terms
are
of building
interrelated,
regs.
aren't they?
Yeah.
So there's also the dust emissions during construction as well. I mean, that's covered by condition 14.
Yes.
So there is an overlap there as well.
But no doubt the measures have been built in part in response to the development plan policy requirement.
Yes, yeah, absolutely. There is support for it, yeah.
Yeah.
Right, okay. That helps me understand what it relates to, that's all. I wasn't quite sure what you were expecting in terms of a scheme.
Yeah,
and
so it
measures.
relates to section 12 of the committee report and the on-site mitigation measures proposed in this instance are the electric vehicle charging points, the green roof to the pavilion, and cycle parking spaces. But there will also be the new border specifications as well.
Right, okay, that's helpful. Yeah, that helps me understand it. Okay. Right, so 13 requires an asbestos survey and disposal plan, which is fine. 14, construction management plan, which again is standard practice really. The only thing I wanted to question is number 7, construction demolition routing plan. Is that enforceable? There's an ongoing debate about this, I think, generally.
Well, what's enforceable is the production of a plan.
Absolutely. Compliance with that plan is the issue.
And then what's enforceable is how that plan should be communicated to drivers, for example.
Yeah.
If at the end of the day the drivers don't do as they're told, then that's where the enforcement difficulty comes in. But what we can do is to try and make sure that the situation in which that arises is minimised by clear communication and instruction.
Yeah. But you can only do so much, can't you? Yeah.
If it helps, we have on another development in the borough had the same issue around enforcement of the construction demolition traffic management plan, and we have issued enforcement notices against companies when the plan has not been followed. So we do monitor it and take action.
Right. Okay. Right. I just wanted to query that because it is very often a difficult area in terms of enforceability and does raise its head in a number of developments.
Well, if we ever get to an enforcement inquiry, you'll be able to decide.
I don't do enforcement work, so it won't be me. Okay. Right. Where are we then? Yes. Number 15 looks at contamination and the usual monitoring of that, measures to control any gas protection, verification. That's fairly standard. Do we have a reference for the preliminary report in A there? Set out in part 7 of the preliminary report. Would it be helpful to put a reference in?
Yes, I can find that.
Yeah. Yeah, I think that might be just helpful us to clarify exactly what that document is and what it is. Right. In part D, which is the precautionary clause, if any contamination is found that wasn't previously expected, should that require the development to cease at some point until a remediation scheme is agreed and submitted? That would be the normal wording of that. I'm not quite sure how the council normally operates this condition.
This is our standard condition. It normally is based on what type of contamination is found.
Yeah.
And then we would work with the developer in terms of moving the development forward. But we could insert a clause as to the development ceasing. Yes.
Yeah. Do you have any concern or objection to that?
No, Mark.
No? I think it is fairly standard practice normally that you cease development until further investigation is undertaken and then mediation scheme agreed.
Agreed.
Yeah. Okay. Right. Number 16. Yes, submission of finished floor levels to be submitted and approved, which is fine. 17 is the water regulation condition, 110 litres per person per day, which is the increased water measures under the building regs. So are we in an area of water stress here in Rugby? Is that the basis for that condition and the policy?
Yeah, under the policy SDC 7.
Yeah, that's fine. That's okay. Then 18 is a passive electric vehicle charging point to be provided to each dwelling. And 19 relates to broadband infrastructure to each dwelling, which is fine. 20 looks at the access. No occupation until all parts of the access within the public highway, not included in the permitted means of access, have been closed. curb footway verge reinstated. 21 then requires a tree protection plan and method statement to be approved. Is that necessary at reserve matters stage, or is it appropriate at outline stage?
We deemed it to be appropriate because there's TPOs along the whole of the front of the site.
Yes, I understand that.
So in relation to the access, we thought, well, it would definitely.
So you preferred that conditioning now rather than at reserve matters stage when you have the landscaping details submitted? Because there is a connection to that, isn't there? It is related to that, really.
Yes, it does. But in terms of the outline, the access will go through the TPO. So it removes the trees. So we know that we will need it for that element.
Right, okay. Right, that's fine. 22, so no retained tree shall be cut down, uprooted or destroyed. That's fine. Other than in accordance with the approved plans. All tree works to be carried out in relation to the usual BS reference. Then 23, we look at PD rights being removed effectively. No walls, fences, railings, gates or other means of enclosure be erected or placed in front of the dwellings. Can I just query this? Because looking at the layout, there are some corner properties. So it's your definition of in place at the front of dwellings. So when you have a corner property, you've also got a side that's adjacent to a highway. So does that need to be amended? Do you understand the point I'm making?
Yeah, I understand the point you're making. In terms of PD at the side, though, they could only do 1 metre side. So we didn't feel it was necessary to...
Well, under PD, can't some... Yes. You can only have one front, can't you?
Yes, principal frontage, isn't it?
But then but sometimes if there are 2 candidates, you just have to choose one.
Yeah, it gets messy.
Yeah.
That's a technical phrase.
Yeah.
Right.
But
I mean, it's just a point to make. If you're content with that in terms of it meets your objective, then we could leave it. But it's just a question really, because some dwellings are effectively corner properties.
No, I understand the point, but yeah, we're content with that.
Right. Okay. Any comments from you, Mr. Hooper? No? You're okay. Okay, good. 24. Again, is PD rights. Garage is not to be converted to living accommodation, so they're retained for parking. Yeah, that's fairly standard. 25, archaeological work, programme of recording, which is fine. 26, disposal of surface water and foul sewage. A scheme for that to be submitted and agreed. 27, landscape and ecological management plan to be submitted and approved. Right, I note that is looking for maintenance in perpetuity rather than the 30 years under the Environment Act. I'm quite happy with that. I presume the appellant is content with that. Yeah.
Yes, ma'am.
Yeah, that's fine. I know the Environment Act doesn't come into effect till the 1st of January now. It was delayed, wasn't it? Okay, that's fine. 28 requires a construction environmental and management plan. Which is fine. 29 looks at an ecological scheme to be submitted and approved, including details of habitat creation, bat and bird box locations, access gaps for hedgehogs. Should that, there's the last sentence of that says the agreed scheme shall be fully implemented before or during development of the site as appropriate. Is that precise enough?
It's envisaged that the scheme will set out which elements have to be put in place at which point. So it depends on the mitigation. So, for example, the hedgehog holes in the fences can't be before the development, so they would have to be during. But there may be other details that are set out and agreed that have to be implemented before.
Right, so you're content that would be covered by the scheme submission, effectively?
Yes,
Yeah. Okay, all right. Right, 30 looks at external lighting. And I understand the basis for that, that's fine, particularly in relation to woodland areas and the potential impact for protected species. Is it necessary for the bullet points to be included in this condition?
No, ma'am. They can be excluded.
Mr Hooper, I don't suppose you're particularly worried whether they're in there or not. It just seemed a little bit excessive to me, that unnecessary. The scheme will conclude it anyway and make reference to it. Okay, thank you. 31, flood lighting and boundary treatments to the sports pitch. Yep.
On this one, Ma'am, shouldn't this be a pre-commencement condition, given the greenbelt location and the proximity of the floodlighting to existing housing, and therefore the controversial nature of floodlighting? Thank you.
So you're looking for that to be prior to first occupation, is what you're saying?
Well, certainly that, yeah. But also, I mean, shouldn't that be sorted out before the commencement of development?
Well, there are options, I suppose, there. I mean, as provided that a scheme is submitted and those details are approved before the use of the pitch. That's the key point. Can I ask Miss Casey?
We're happy with it as drafted.
Right. Mr Hooper?
We're happy as drafted.
Right, okay. So you're looking for it before first occupation?
So that would be an improvement.
Okay, something I'll look at then. I'll make a note of it, and it's something I'll have a look at.
I think the only comment I would make, ma'am, is at that point we'll obviously have the reserve matters approval, so we'll know the landscaping. We already know where the future dwellings will be and where the existing dwellings are. So in terms of it being pre-commencement, I'm not sure what further details would be required to shift that approval forward, really.
Yes, I mean, there are different ways of drafting a condition, and effectively it's what the objective is and what you're trying to safeguard. Yeah, but I'll have a look at it anyway. I'll take on board the Rural Six Parties' comments. Right, 32, surface water drainage scheme based on sustainable drainage principles to be submitted and agreed. Does that, to an extent, duplicate condition 26? I just want to understand the relationship, because that's looking at surface water sustainable measures, SUDS effectively. 26 requires drainage plans for disposal of surface water and foul sewage to be submitted. So is there an overlap there?
Yes, there is an overlap, and we would say that condition 32 is more detailed.
Yes, it is. I'm not saying lose condition 32.
Oh, yeah.
Yes, I'm saying it is more detailed and it is thorough, which is fine.
Yeah.
Do you think condition 26 should be modified? So maybe remove reference to surface water, so it just looks at foul sewage. So you've got separate conditions for foul and surface water.
Yes.
Yeah?
Yeah.
You content with that, Mr Hooper? Yeah?
Yes, ma'am.
Okay, thank you. Yes, there's quite a bit of detail in condition 32. Then we go on to 33. No development shall take place until a site-specific maintenance plan for the drainage scheme. Yeah, which is fine.
Ma'am, I think the only addition we would make is to add drainage into the condition, so it's more specific, so it says site-specific drainage maintenance plan.
Yeah, okay, that's fine. Mr Hooper, are you content with that?
Yes, we suggested that.
Clarity, yeah. Okay. Okay, thank you. It says that no first occupation or subsequent to use shall take place. Is that the best phraseology? For consistency with other conditions. Normally we'd say prior to first occupation, wouldn't we? And use. No
Yes,
development shall
happy to
take
change
place
that,
or whatever, yeah.
Yeah.
Yeah. Okay. 34 is looking at fire hydrants within... Sorry? Yes, it does. You're right. I have actually spotted that. Yes, you're right. I've crossed it out on my draft
be
here.
removed.
Yes, I have read it. Yes, you're absolutely right. Yes, I've crossed it out. Yeah, I missed that. Yeah, that's fine. Yes. Is it necessary to have this condition, or is it covered by other legislation?
The fire services asked for this condition, and we do think it's necessary in accordance with policies in terms of providing safe communities.
Yeah. Yes, I understand that. Yes, and you've got a policy reference there. Yeah. Okay. You can with that, Ms. Hooper.
We did question the point, Ma'am, in terms of it being covered by building regs.
Yes, that's what I was thinking.
Yeah.
Ma'am, it's, if I can put this as neutrally as possible, it's a Warwickshire Fire and Rescue Service specific request which arose, I think, out of a tragedy a few years ago when some fire officers were killed. I'm not sure it was directly related to this, but they had
the principle, that's how it arose.
Branch look at this.
So it's precautionary.
I think it was the warehouse
Condition.
packing fire, wasn't it?
Was it Atherstone?
Yeah.
Right, okay. All right, that's helpful to see that background. Okay. Okay then. Right. 35. Home access arrangements constructed and laid out in accordance with the approved plan. I would probably delete the or another appropriate scheme submitted rather than having this tail piece and this giving the opportunity to amend it at this stage. Mr. Hooper, have you any view on that? Yeah.
Yes, ma'am. The only reason highways usually include that is if there's any section 278 or 38 scheme that slightly amends it.
Yeah,
and they just do that so there doesn't have to be a variation of condition or non-material amendment, that's all.
Fair point, yeah. Right, okay, yeah, all right, maybe we'll have a look at the wording of that then.
What it's doing is it's saying either it's the current plan or it's a scheme to be submitted.
To be submitted then agreed, yeah, which
So,
would be the 278
yeah.
revision. But effectively it'd be the same scheme, just probably minor
Yeah,
modifications.
and so it's not really a tail piece.
No, okay, all right, take the point. Okay then. 36 looks at widening of the footway to provide shared pedestrian cycle use between Gossett Lane and the crossing before occupation of the first dwelling. Yeah, that's okay. 37, parking and turning for each dwelling before occupation. 38, car parking for the sports pitch to be provided in accordance with details prior to the pitch being brought to use. Yeah. 39, no development shall commence, excluding demolition, until details of the specification of the 3G sports pitch has been submitted. Now, my question here is that necessary? This is also within the 106. Requires a scheme as well, or is it sort of belt and braces from the council's perspective?
It's just belt and braces, yes, because we weren't, well, we still don't know the exact specification of the sports pitch. So.
Right, okay. Yeah, Mr. Hooper, are you happy with that?
Yes, ma'am.
Yeah, you're okay. Okay. 40 looks at the sports pitch. Hours of use, no later than 21:30 hours, lighting to be turned off 30 minutes afterwards, which is standard to protect the amenity of residential properties. Sports pitch to be laid out and available for use before the occupation of the first dwelling. Yes, I want to question this as well.
On 40 I had a comment,
Okay,
which was that at Walston the turn-off point, or the closing time there is 9 o'clock.
Right.
And the existing housing is closer to that 3G pitch than the one here, I believe. So we would suggest that that should be 2100 hours.
Right, and then if the lights turned off 30 minutes afterwards, which
Yeah.
would be 9:30 then, wouldn't it?
Yeah.
Council, any views? Do you have a standard hours for 3G pitches? Some authorities do. They have a
We
usual
don't have standard
policy.
hours, no. That was just in consultation with our environmental health officer.
Okay, all right. Mr Hooper?
Mum, this goes back to kind of viability,
Yes,
and obviously the business plan is
you're
set
losing half an
out.
hour, in other words.
Yeah, we would be losing half an hour. No evidence has been submitted in relation to that relationship. Details will need to be submitted in relation to the lighting. So whether in any way it can be linked to the details around the lighting and the hours linked to the lighting specification, because at the moment we're not talking about a lighting specification. Flood lighting is referred to. KKP would say it's not flood lighting anymore. It's very directional lighting, and therefore the issues that I think Mr Carter is outlining perhaps have moved on.
There is an argument if it's acceptable at 8 o'clock, it's acceptable at 10 o'clock.
Exactly, Mark.
Because it's still dark, yeah. Okay. All right.
Mum, there is the question of the noise that goes with the use of the pitch as well. It's not just the lighting, is it?
No, I take your point, yeah, that's true. Okay, it's something I'll review, taking on board your comments.
Ma'am, just to pick up on Mr Carter's point there, condition 45 that we'll come on to does look at noise in relation to the pitch. So, you know, that issue would be picked up separately under 45.
Yeah, okay, yeah, fair comment. Right, number 41. Yes, I want to discuss this one. This is requiring the 3G pitch to be laid out before occupation of the first dwelling. It's a question of consistency here because the pavilion isn't being required until 50% of the dwellings have been constructed. In other words, there's some people occupying the site who are then going to use the facility. The 3G pitch, to have that available before the occupation of the first dwelling, is that too early? I want to understand what the objective is here.
But the objective is that is a significant benefit of the scheme. So
Yes.
for it to come forward at the same time as the dwellings would be appropriate in terms of it should be available for use at the earliest instance.
Yes, I can understand the principle of I want to ensure that it's there, provided and available for use at an early stage.
Pavilion waiting coming along behind it 2 years later. Where they're going to change for the first
The
2
pavilion
years.
should be at the same point as the pitch being available.
This is the point really, it's consistency.
Yes,
That all those
no,
facilities
agreed.
are there at the same time, put it that way.
Yes, no, agree with that.
Yes. Okay, so do you want to amend the other condition then?
Yes, yes.
I can't remember which one it is now, I have to look back. Has anybody got it? Oh, there we go. Condition 9. So you want to change that to first occupation? Mr Hooper, do you have any views on that?
I agree, Ma'am. I think it probably does need to be consistent in terms of the offering. You know, the pavilion and the changing facilities is an integral part of that
Yes,
facility.
exactly. So they need to be there at the same time, effectively. Okay, all right. Thank you.
To ask one, because that's, if I can just raise this, does this square with the section 106? Are they going to be consistent there?
Good point.
Yes, this has been raised by the appellant, but we're of the view that this condition is not exactly the same as the section 106. So if the appellant wants it in one place, that's fine. It can be within the section 106, but we would need to amend.
Just remind me what the difference is.
So this says it has to be laid out and available for use before first occupation.
Yeah.
Whereas the section 106 is slightly different. It doesn't say it has to be available. It just
No,
says
the 106 says prior to the first occupation development, the owner shall lay out, install and complete the sports pitch, which includes the pavilion by definition, in accordance with the approved construction scheme.
Right, okay, so it's slightly different wording. Yeah.
It says it has to be complete.
Yes.
It doesn't say it has to be available for use.
Right, that's the difference, yeah.
It may be that we're all singing from the same hymn sheet.
But if it's complete, they're going to want to start operating it. They want to start getting some money in, aren't they? One would presume. Right, okay. So are we content to continue on that basis, or are we looking for any amendment?
No, my point was simply, if it's covered by the 106, then there was no requirement for the condition. If we indeed amend the 106 to pick up this point.
I mean, although one would normally say condition rather than 106,
Yeah.
given that there are all sorts of other provisions relating to the pitch and the pavilion that would have to be in the 106, it might make sense in this instance to have it all in one place.
Yes, it does sometimes, yeah. Okay.
But that would mean amending, that would mean taking out both condition 41 and condition 9, and if need be, at paragraph 3.1 on page 36, layout, install, complete and make available for use the sports pitch.
Right. Yeah, just a slight wording modification.
And then, as Mr. Chapman reminds us all, sports pitch by definition in this document includes the pavilion and the car park.
Right. Okay. Does that, are you content with that, Ms. Hooper?
I'll just double check that the car park's included in the
I
definition.
think it was, from recollection.
It is, I think, Ms. Casey.
Yes, it is.
Ms. Casey's point is we have a
And then Ms.
condition.
Casey's point that condition 38 could come out because that's the car park.
Yes. Okay. Right. Right, okay. Right, where are we up to? It was 41, wasn't it? Yes. Right, 42. Requires details of the leap to be submitted, and that no dwelling shall be occupied until that leap has been provided. Yeah, we all content with that? 43, then it goes on to look at the retained northern access and the reconfiguration. Yeah. Okay, that's fine. Number 44 then looks at waste recycling, storage and collection. I'm just wondering whether this one is actually necessary or should we reword it slightly. I'm just not quite clear why there would likely to be a collection point space within the scheme, bearing in mind the layout.
It's based on the private driveways, so there would have to be collection point spaces for those.
In practice, is that true? Would you have a collection point, or would people just put the bin at the end of their drive?
Depends how many dwellings. So if it's a couple of dwellings, they would just be, they would just put it at the end of the drive. But there's some longer private drives in this layout which would require a collection point usually.
So what would the council be expecting by way of a scheme to be submitted?
Just to set out where the collection points will be and the provision of them. So would it just be a space of hard standing? Right, so really you're just looking for to be clear, there's an area of hard standing that's available for the bins to be put out. Yes, and a distance, because the bin lorries obviously will not go down the private drive, so it has to be within a certain distance.
Yes, that's right, carrying distance and what have you, yeah.
Yep.
Right, okay. Ms. Hooper, are you happy with that?
Yes, ma'am.
Yeah, okay. Okay then, right, that's 44. We're getting near the end. 45, noise assessment for the 3G pitch and external amenity areas. Presumably that noise assessment may then recommend mitigation measures.
Yes, it could, ma'am.
Right, so would that be things like non-reverberating fencing and all that sort of thing to keep the noise down?
It could
There
be.
are buffers in the fencing, don't you, sometimes to stop it rattling if a ball hits it, that sort of thing?
Yes, it could be, yes.
Okay. Yeah, Ms Hooper, you content with that?
Yes, ma'am.
Yeah, you're okay with that? Okay. 46, last one. No development above foundation levels shall take place until a plan indicating the position and design materials, boundary treatments to be erected in relation to drawings have been submitted and approved. And those treatments to be in place prior to first occupation. Is that necessary? Does it repeat condition 11?
Yes, ma'am, it does repeat it. I think 46 has a bit more detail.
Yes, so we could remove 11 and keep 46 if you think that's appropriate.
Except that 11 might be dealing with walls, fences, railings and gates that are not boundary treatment.
Yes, ma'am.
Walls, fences,
Yeah, they could be amalgamated, so
Yeah.
to set out that it needs to be
yes,
boundary
I see
treatment
your
plus
distinct. Yeah,
other-
okay.
I think just on that, it was a good point in relation to these are not necessarily boundary treatments of the properties. These are boundary treatments on things like Speedway Lane. So there were details.
Right, so it's in the wider development
Yes,
rather than the individual.
there is a requirement for us to
okay, I'm with you.
engage on
Right,
the Speedway
yes.
Lane existing treatments.
Right.
So I think that's you're correct.
Right, okay, that's fine. Yeah, I understand that. Yeah, that makes sense. Okay. Right, so at the end of our list of conditions, I don't like to ask the question, is there any other conditions that aren't there that anyone feels should be?
No, Madam. May I just come back just very briefly on
sure.
conditions 1 to 3? Just something you said. You said these are very much standard conditions for timing of
Right,
submission.
yes,
of this.
well, effectively they are
Yeah,
to be.
we often see, certainly in the last decade or so, inspectors thinking on a particular case, of course, that actually consistent with the case, we ought to be shortening these down to a year, for example, must be
Yes,
submitted.
but
I just mentioned that because
yeah, I agree, yeah.
it's if one's saying we're going to be meeting an existing affordable housing need and we're going to be meeting existing 3G pitch, and then you say, well, you've got 3 years to put in your reserve matters, and 2 years after that you don't start.
Yes,
Yeah.
Yes, so really, it's really what you're saying is it's the commencement.
Yeah, and whilst I entirely understand what Mrs. Chapman said in relation to Section 106, exclude demolition in terms of the trigger points for payments, I understand that. But from the planning point, which comes to the conditions, again, if I don't understand the planning reason for excluding demolition from the conditions, in terms of the development excluding, in condition 1, the development hereby permitted excluding demolition must be begun not later than the expiration of 2 years. It's a separate point to the Section 106. It's just in the planning condition. Anyway, I'll just leave that thought with you.
Okay, all right, thank you. Do you want to comment, Council? Do you want to respond to anything there?
Not particularly, no.
No, okay.
No, there are standard conditions, so.
Okay, right. Okay, I'll look at the issue there. I understand the point Mr Humphries is making. Ms Trooper, anything finally from you? Right.
The only observation from me on terms of shortening of time is the provisions in Section 92 are the statutory provisions. There's also the guidance provisions as well. It's only in circumstances where there is a particular significance to meeting a need more quickly. One of the features about most planning cases that end up at a Section 78 appeal is the examination of a need. That need is normally there.
Yeah.
If the need was sufficient in all instances simply to, of course, shorten all of the time periods, then the time periods would be rendered really without any particularly good effect. That's the reason why I think the PPG with regard to housing says if there's something very particular
Yeah.
and specific in terms of housing land supply, then
Yeah.
that may be contemplated. But I
Yes,
think that is the
yeah,
only
that's right.
circumstance in which it is raised. And I don't want to really prolong the debate really much more than that.
No, I mean, I am aware of that position, yeah. No, that's fine, yeah. Okay, so I think we can draw that session to a close. So we'll take a break now. Excuse me. So, as we said before, to give you the opportunity to discuss some of the finer points of the 106 over a break as well. How long do parties feel would be appropriate? What I'd like to try and do is get at least one closing submission in before lunch, before 1 o'clock, if possible.
A batting order for closing submissions. I can't remember.
Batting order should be council first, isn't it? Then appellant last. Rule 6. Rule 6, council appellant, yeah?
Yep, that's fine.
Is that
Good.
okay?
Yep.
May I just ask, do you, you mentioned the case law to which I'm referring.
Yeah.
Have you got that electronically, or would you like a hard copy?
No, I don't need
I didn't
hard
want to
copy.
give you paper.
No, I don't need more paper, thank
no,
you.
No,
I'll
no,
put it
that, I just thought I'd
As
give
long as
it
I've
to
got the
you.
references, that's the key thing for me.
That's right.
If you point out the individual clauses, paragraphs, that's basically
Exactly.
all I need.
That's what I'm doing.
That's fine. Yeah, that suits me. Okay, so yes, how long a break do we require?
Till 12 o'clock, and that should
Till 12
allow...
o'clock, that should be adequate, shouldn't it, for everybody? Yeah, as I said, I'd like to try and get one closing submission in before lunch, if that's possible, in the hour. I did say an hour per party, Mr Humphreys, I know.
I know you'll be the
And
first.
we have 3 to sit through.
As long as you don't ask me any questions, madam, I'll finish.
I won't answer, I can't promise.
And you don't ask,
We will.
and if you do ask me any questions, then I shall take
It
a
will
bit longer.
prolong things, yes, fair enough. Okay, well, that's the target anyway. Well, actually, yeah, we'll probably need a little bit of time just to go back over what your discussions are as well, so...
Indeed. Can I just say, in terms of the closing submissions, they are going to be in writing.
Yeah.
What I was going to suggest, if that's permissible to you, is that, yes, I can, certainly as far as mine, which run to 31 pages, read them out in extenso, or there may be bits that I summarise, but leave you with the elements that are there for your own reading.
Right. In terms of efficiency, I'm very happy to hear summary rather than full detail, because as you say, I can clearly read it for myself.
My closing's 17 pages, so I'm confident I shall be easily
Within the time.
within the hour.
Oh, excellent. I'm sure we'll get through it all today anyway. The aim is to get done before 5 o'clock, because I know Miss Casey did remind me that the room needs to be vacated by 5, so... and I think everyone wants to get away anyway.
There are King's Counsel known to the three of us who would take considerably longer.
Just King's Counsel.
Right. Well, you've got the point anyway. Right, okay then. So in that case, we'll adjourn then till 12. Okay, thank you everybody. thank you very much, everybody. We are just about on 12 o'clock, so we will resume. So perhaps one or other of you can lead me through your discussions over the break. So, yeah, Ms Chapman, please.
Thank you. So we were discussing the maintenance fund and sinking fund, which was the outstanding point on Section 106 agreement. The position we've come to is that the maintenance fund, which will be a lump sum of 58,500, index linked as appropriate, 500, will be paid to the council in line with the trigger for when the sports pitch and pavilion needs to be laid out and available for use as per 3.1 of the Section 106 agreement. That will be held in an interest-bearing account by the council, and then this will taper over the 10 years. So for each year the council don't need the sum, they will pay it back starting in year 2, and then the last bit will be returned essentially in year 11 to ensure that funds are available if there's a failure towards the end. So that's the maintenance sum element of it. In relation to the sinking fund, this was what has been accounted for in the business plan of the management company. So for that, there's a sum of 29,250, which is the Sports England calculation, which will be paid annually on the same trigger point as when the sports pitch is made available for use, and then annually thereafter, index linked, and that again will be held in an interest-bearing account by the council. And then at the point in which the sinking fund is required to be used, which is anticipated to be the 10-year point when the 3G pitch needs recarpeting, whoever is at that point operating the facility, i.e. the management company, the council, or another, will be able to draw down those funds to do the relevant capital replacement costs. And then any balance and interest remaining thereafter, because we think this is probably a slightly higher sum than is likely to be needed, will be returned to the developer who paid the money to start with. And again, that availability window will be there for a couple, I think 18 months we decided after that 10-year period, to ensure that the council's got a bit of flexibility if it has had to step in and draw on it.
Excellent, that's really helpful, thank you for that. So in terms of the agreement and its redrafting, clearly you need a little bit of time to do that, which is fine. Any suggestions on how long you may need to do that, agree the wording and then get signatures?
So we're anticipating that the draft will be redrafted this afternoon and circulated by the appellant's solicitor, with us to review it over the course of tomorrow and the day after. So we anticipate that we'll be able to finalise the 106 terms this week. We will then need a couple of weeks to circulate for signatures and execution by the County Council and ourselves.
Yes, you just need to go to them as well, doesn't it? So are you looking, what, say 2 weeks on Friday? Whatever that is? Would that be adequate? That sounds like plenty of time to me.
Just working with round figures, how about 3 weeks, ma'am? Would that be agreeable to you?
Can do it if you like.
That would be helpful.
From today.
Yes. Yeah. Thank you.
Thank you,
Which
ma'am.
from
That's
today,
very helpful.
which let's just check what that is actually. 19th of December then. Yes, that needs to be a signed and certified copy, electronic copy sent through to PINS. Okay. Thank you.
Thank you, ma'am. That's very helpful.
No problem. Anything further on that? Are we happy to continue then with
community use
submissions?
agreements?
Oh yes, sorry, ma'am. There's a couple of other minor drafting points to sort out, and then on the community use agreement definition, we're just going to add one bullet point to that definition with a minimum of 15 hours a week community use.
Oh, right, okay, that's fine.
Thank you.
Okay. All right, super. Good. Okay then, so we're now then moving into our closing submissions, and Mr Humphreys for the Rule 6 Party is going to kick us off. So I'm gladly you've got a written version of your statement there. Thank you very much. I can also confirm that I have seen the closing submissions by Dr Bowes now. I've got that through. I have read that over the break.
And I will have some comments about it in my written
That's
closing.
fine. That's okay. Okay then. So, when you're ready then, Mr Humphreys.
Thank you very much.
Thank you.
I'd ask that this closing statement be read alongside my opening statement. then go through the main issues in the order in which they were mentioned. First of all, the green belt. SCS take the view that the proposed development constitutes inappropriate development in the green belt. Mr. Carter did query the extent to which the whole appeal site is previously developed land, but his main point as to whether the exception in NPPF paragraph 149G is applicable is as to A, whether the development would have a greater impact on the openness of the green belt than the existing development, or if and insofar as it would meet an identified affordable housing need within Rugby Borough, B, whether it would cause substantial harm to the openness of the green belt. NPPF paragraph 137 is an important starting point. Well known, the government attaches great importance to green belts. The fundamental aim of policy is to prevent urban sprawl by keeping land permanently open. The essential characteristics of green belts are their openness and their permanence. Openness can have visual as well as spatial aspects. Extracts from relevant, well-known and uncontroversial case law is set out at Appendix A. And my footnote 1 just summarises the 3 points that I draw from that. That first, openness is the counterpart of urban sprawl. Secondly, openness is not necessarily a statement of the visual qualities of the land. And thirdly, consideration is not limited to a volumetric comparison. Indeed, less volume could have a greater impact on openness and vice versa. Back to paragraph 5, a substantial part, indeed the majority of the appeal site is open and free from buildings, the stadium buildings being set well back into the site. It's no accident the appeal site was and remains included in the green belt. This openness is apparent from Rugby Road in particular, as well as Speedway Lane. Whilst there is a ribbon of existing housing fronting Rugby Road, including bungalows as well as houses, 1, this covers only approximately half of the frontage. 2, until the temporary security fencing was erected, open views along Rugby Road were afforded by existing accesses. And 3, there is an accurate impression of openness behind, that sense of openness behind. The proposed development, which would be sited much closer, we estimate approximately 80 metres at its closest to Rugby Road than the stadium buildings, would be very apparent from Rugby Road and Speedway Lane. Moreover, the Council's Landscape and Arboricultural Officer referred to the removal of TPO oak trees along Rugby Road as leaving a large 23-metre gap, with views being opened up into the site. Screening landscaping and or the device of a dogleg in the proposed access road can hardly be said to preserve openness. The suggestion by Mr. Child on behalf of the appellant that the proposed housing would be in keeping with, and I quote, consolidate the morphology of the settlement of nearby Binley Woods, was both misplaced and revealing. That settlement is not within the green belt. In addition, the proposed development would be some 350 metres from the defined settlement boundary. The proposed development would considerably add both to the amount of built development and the coverage of it on the appeal site, and thus not safeguard, but instead suburbanise the countryside beyond Binley Woods. It's important too to bear in mind that the function of this part of the West Midlands Green Belt is in part to prevent Coventry, whose eastern bypass lies almost immediately to the west of Binley Woods, from merging with Rugby. Mr. Carter drew attention to the fact that if one were to draw a line between the city centre of Coventry and Rugby town centre, the appeal site would lie approximately halfway along that line. That line continues to the east along the A428, passing through a number of settlements on that road, and the appeal site is only 8 kilometres from Long Lawford, which Mr. Carter referred to as expanded Rugby. This emphasises the sensitivity of this gap in the context of the proposed strategic size development. Purposes B and C are thus of particular relevance in this case. The Council's planning officer in the present case appears to be misled by the then applicant's assertion that the development coverage of the site footprint of the buildings would be reduced by the proposed development from 4.35 hectares to 4.1 hectares. Upon analysis, this is clearly factually incorrect. Mr. Carter provided statistics when he gave evidence which suggest an increase both in footprint and in coverage of the appeal site, built footprint and the coverage of the appeal site, and these figures have not been contradicted. The figures given in evidence are set out at Appendix B, page 35, are simply they're already figures that you have, it's just a single sheet. In addition, reference has been made by SCS to the impact of floodlighting columns, 4-metre high closely meshed fencing around the 3G pitch, and other related paraphernalia. Whether considered in spatial and or visual terms, therefore, SCS considered that the proposed development would clearly have a greater impact on and cause substantial harm to the openness of the green belt. As Mr. Carter pointed out, if the foregoing had been appreciated by the planning officer, the officer's recommendation may well have been different. If it be accepted that the proposed development is therefore inappropriate development in the green belt, it is considered that very special circumstances have not been demonstrated, i.e. all the harms are not clearly outweighed by other considerations. If this view be taken, then great negative weight is to be attached to this breach of national and local policy. Issue 2, whether the stadium is surplus to requirements. As observed in opening, neither SCS, the Council, White Young Green consultants, nor any of the respective sports governing bodies and related organisations regard the site as surplus to requirements. A central part of the appellant's case is that both speedway and stock car racing are in terminal decline. It was genuinely baffling to SCS that Mr. Osborne, assisted professionally by Mr. Hooper, should actively be seeking to promote a new site for speedway and stock car racing in the Swindon area, if it were really believed that speedway and stock car racing are in terminal decline. Mr. Osborne, and Madam, just for your footnote, number 9, you'll recall your question to me, is that a question? When I exclaimed, I asked, paused and said, are we playing games to Mr. Osborne? But the reason for that was, I hope, is now apparent. Paragraph 18, Mr. Osborne, however, under cross-examination, this is the key point, denied that that was his belief. He wasn't saying that they're in terminal decline. That was a very important denial because it undermines a central part of the appellant's case that the appeal site is surplus to requirements. Mr. Hooper's position at this inquiry appears to be carefully crafted, if I put it in that way. After all, he too is supporting the Swindon proposal. He states in his proof that Speedway is severely challenged, but he is careful not to state that the same applies to Speedway and stock car racing combined. It's highly pertinent to note that stock car racing had run alongside Speedway at Brandon for 62 years and had therefore been an important factor in the ongoing viability of the stadium. We say that the stadium is plainly not surplus to the sport of Speedway racing's requirements. Mr. Ford, a very successful Speedway promoter at Poole, wishes to resurrect and promote the Coventry Bees. And Mr. Eadie did not contradict Mr. Horton's statement as to the need for this to occur in the Brandon/Rugby area. Nor, under cross-examination, did Mr. Eadie suggest that there was another venue in that area that could accommodate a Speedway track. A requirement is, of course, most unlikely to be surplus if it cannot be met elsewhere. The stadium is plainly not considered surplus to Speedway racing requirements by that sport's national governing body. This is not surprising, not only because of the close and long association of its history with Speedway racing in the UK and the West Midlands, but also because it has one of the best shale tracks in the country. The West Midlands, a large and populous area, is likely to be devoid of Speedway tracks if this appeal be allowed. The threatened closure of Birmingham Speedway follows the recent closure of Wolverhampton Speedway. Moreover, the appropriateness of the central location of the appeal site relative to the trunk road and rail network serving the UK is manifest. As regards stock car racing, firstly, the fact that it's not currently recognised as a sport by Sport England does not, of course, preclude it from being a sport too, nor, for that matter, a recreation, also within the purview of NPPF paragraph 99. Moreover, the test is whether an assessment has clearly shown that the land and/or buildings are surplus to requirements, whether sporting or recreational. Secondly, the appeal site is the location of the Wembley Stadium of that form of racing, just as, for example, Silverstone is to Grand Prix motor racing. Thirdly, only Hensford Raceway, would remain in the West Midlands, yet that venue has severe restrictions over the number of events, days and hours in which it's permitted to operate. The foregoing analysis is entirely consistent with NPPF paragraph 98, which directs a decision maker to consider both quantitative and qualitative issues in respect of the requirements of sport and recreation facilities. The focus of ANOG's, Sport England's Assessing Needs guide, is on participation in sports. The matters set out in paragraph 2 above are likewise participant focus, and any sensible application by analogy of the guidance in ANOG, should it is submitted, result in the conclusion that the appeal side is not surplus to the participants' requirements. Obviously, sports such as speedway and stock car racing need both venues and spectators. To focus on participants only without any regard to the spectators who support the sport would be inappropriate. Coventry Bees is an apt example of the interrelationship between the location of a venue for participants and its spectators. NPPF paragraph 93A includes sports venues as community facilities. Paragraphs 93, 98 and 99 likewise together refer to, first, the provision of social and recreational facilities which the community needs, taking into account the health and social well-being for all sections of the community, guarding against the unnecessary loss of valued facilities, and requiring robust and up-to-date assessments of the need for sport and recreation facilities, including quantitative or qualitative deficits or surpluses, and requiring replacement by equivalent or better provision in terms of quantity and quality. Whilst participation in sport is of course a very important aim, the framework is concerned also with the provision of facilities for spectators to attend to support their team and thus to take part in social interaction, which in turn contributes to well-being. Policy LF1 of the Neighbourhood Development Plan recognises the stadium as a valued community facility. It is not only valued locally, but nationally and indeed internationally, as the many representations referred to in the officer's report to committee make clear, and as the vast majority of the representations made clear in response to the notification of the appeal also attest. Mr. Allen undertook an independent review of the respective claims of SCS and the appellant in 2018-2019 and spoke to all concerned. Notwithstanding Mr. Allen's previous view as to the declining interest in speedway and stock car racing, his view clearly changed having reviewed SCS's written representations and spoken to SCS and the respective governing bodies. The evidence at this inquiry in SCS's view simply reconfirms the appropriateness of his conclusion. What has been noticeable is the failure of KKP to address any of the many detailed points raised by SCS going back over at least 2 years. Some are now accepted, but only after cross-examination. Curiously, the witness called by the appellant, Mr. Eady, admitted that speedway and stock car racing was not his expertise and that he had not written the speedway viability assessment or its update. Mr. Eady's evidence was based on a lack of expertise, on assumption, and on inadequate investigation, made worse for not having addressed any of the many points raised previously by SCS. Mr. Eady stated that much of KKP's information was derived from desktop research. Whilst official sources such as club websites may have been relied upon for this information, such information is of little use if it's not underpinned by a basic understanding of the sports. And my footnote 20 says that, moreover, the internet, whilst a valuable source of information, cannot necessarily be relied upon to be accurate. And I give an example about the explanation of the closure of Wimbledon Stadium and compare that to the letter that the promoter at the time of closure wrote, which gave a very different explanation to that which is on the web. I digress, come back to paragraph 36. Many factual errors in the original KKP appraisal are found in the tables relating to the number of speedway/stock car fixtures raced, TV viewing figures, the number of operational tracks, etc. And these errors were pointed out in the SCS response. For example, the appellant drew attention in Table 3.1 to the number of Coventry Bees fixtures, contrasting the year 2000 with 2013. In response, SCS highlighted the error in the figures, i.e. double counting postponed meetings and the number of fixtures in a given year being dependent on the team's performance and progression in the league and cup competitions. These errors were not restricted to those 2 years. The errors were made in the analysis of every year, resulting in every figure in the table being incorrect. Despite this having been pointed out in the SCS response, the chart was again reproduced in the updated KKP appraisal. Again, as another example, table 4.2 of the first appraisal refers to the number of teams competing in the BSPA leagues, purporting to evidence a decline in the total number of clubs in operation. But this table does not reflect the fact that several clubs operate more than one team, one at Premiership or Championship level and one for development purposes in the National League. The lack of differentiation between clubs and teams was highlighted in the SCS response. Yet again, the table was simply reproduced in the updated KKP appraisal. Conclusions have therefore been drawn by KKP based on a misunderstanding and therefore misrepresentation of its so-called desktop data. In re-examination, Mr. Eady was asked by my learned friend for his opinion as to the effect on the overall trend should the errors be corrected. He, that's Mr. Eady, asserted that there would be no change. It submitted, however, that the extent and nature of the errors significantly undermines the credibility of this assertion. It's clear that the appellant has not engaged with the national governing bodies. This is a serious omission. Moreover, the appellants were criticised in WYG's 2019 report for not engaging with NGBs, stating that this was an omission and would have painted a different picture in terms of needs and outcomes. Yet this omission was repeated in the revised submission. A summary of SCS's response as set out or given in the evidence to the points referred to by the appellants in respect of the viewing figures and the number of fixtures, etc., is set out in Appendix C, just glancing at pages 36 to 37, so that you can see all what I've done there is just under the headings referred to by the appellants in their evidence: Speedway fixtures, meetings at Brandon; B, UK average Speedway TV viewers; C, number of Speedway teams competing in BSPA leagues; and then for stock car racing, again, just in that one paragraph at the bottom of page 37, analysing the evidence and the responses given to it, which are already before the inquiry, so I won't read through that. Paragraph 44, the appellant contends that viability is relevant to the issue as to whether facilities are surplus to requirements. The concepts, viability, surplus requirements, are, however, different and therefore to be considered separately. Viability is in any event addressed under the next main issue 3, whether it's financially viable to reinstate the Speedway Stadium. Before coming to the detail of the evidence, I refer to the submission set out in my opening, that neglect of the stadium involving the commission of a criminal offence should not be rewarded by the granting of planning permission. I referred to NPPF paragraph 196 as an indication of government policy in relation to listed buildings, designated heritage assets, and there's no reason to suppose that government would take a different view to the operation of paragraph 99, whether that's paragraph 99A or 99C. I'd also refer to Part 11, Class B of the Town and Country Planning General Permitted Development Order 2015, which permits, as well known, any building operation consisting of the demolition of a building, unless Class B1 says, A, the building has been rendered unsafe or otherwise uninhabitable by the action or inaction of any person having an interest in the land on which the building stands, and it's practical to secure safety or health by works of repair or works for affording temporary support. This is a clear indication, I say at the top of page 11, of Parliament's view that results of such actions or inactions of here an applicant appellant should not be permitted to be relied upon by that applicant/appellant. The courts also apply a similar principle, that is, of not being permitted to benefit from here a grant of planning permission from one's own benefit from one's own wrong. Here, the repeated neglect of the stadium, confirmed by 2 criminal convictions, when interpreting a statutory provision. That's a statutory provision, so if it applies to statute, in principle, that it should also and can also apply to a policy, because that's a matter of law as well, correct interpretation. Now, so in relation to statutory provision, where a literal application of that statutory provision, and there it was section 178B2, whether the 4-year rule applied, whether the building had been up for 4 years. Oh yes, it's been up, said Mr. I've forgotten the chap's name in the Welwyn Hatfield case. He'd been given permission for a barn, and then under the guise of the barn, he built a house inside. So the Supreme Court was faced with the situation. Well, look, Section 178 says, 4 years, that's it. And they said, no, we're not going to allow us to just have a literal interpretation. There's a public policy behind this. And it's not a direct comparison, but the principle's the same to this. So when you're looking at paragraph 99, you don't just say, oh, well, it's surplus to requirements because it's no longer viable under C, or whether you have viability under A. You say, look, you stand back and say, no, but we're not going to allow you to rely upon that, on the literal interpretation of that, when that's a result of your own inaction or actions. That's the gist of, and I refer to the Welwyn Hatfield case, I referred to it in a footnote in my opening. I just refer to paragraphs 46, 50 and 54. Don't need to say more than that because I've summarised it effectively, and what that case concerned. Paragraph 50, SCS submit, therefore, that when applying the test in 99C as to whether the benefits of the alternative sports and recreational provision clearly outweigh the loss of the current or former use, that use is in effect to be regarded as viable. It does not lie in the mouth of the appellant to say otherwise. It's submitted, it's clearly open in law for a decision maker so to proceed. So it's a discretion that you have, it's open to you in law if you wish to do so. The counsel in opening expressed the point in terms of not allowing the appellant any credit in the planning balance. That is another way of reflecting the same point, because that's the reasoning behind it, and the result should be the same. Importantly, there is in any event, however, a real, as opposed to a hypothetical, possibility that it will be financially viable for the appeal site to be purchased and use of the Speedway Stadium to be reinstated, notwithstanding the appellant's neglect, albeit in the short term, without the use of the main grandstand. And I put it in that way of a real possibility, because when one's looking at fallback situations, that is the test established, I think, in the case of 1995, but it's been the principle there for a long time. And the court, I remember, emphasised the point, was it real as opposed to hypothetical? Was it a real possibility? Paragraph 52, the inquiry heard evidence from Mr. Hunter that he made an initial approach to buy the stadium in March 2017, but did not then pursue it as the appellant's valuation was based on residential land value. 3 years on the 20th of May 2020, Mr. Hunter visited the site with a representative from Brandon Estates, witnessing the condition, obviously, of the stadium, which had at that time already been subjected to, we think, 2 major fires. Undeterred, Mr. Hunter submitted a formal written offer to buy the stadium 1 week later, on the 27th of May. Mr. Hunter was advised that his offer was being considered and asked for his patience in this matter, but to this day this offer has not been rejected by the appellant. Mr. Hunter told the inquiry that he was the managing director of Hunter Pack Produce Limited, which has an annual turn of £51.8 million and significantly shareholder funds, i.e. equity, of £19.98 million. He confirmed that he has access to the funds necessary to acquire the stadium and reinstate it for racing. He also told the inquiry that he'd met Mr. John Worley and that he was open to the possibility of consorting with Mr. Worley. Mr. Worley is Managing Director of Nationwide Windows and Doors, based in Rugby. On the 31st of October 2022, Mr. Worley sent a letter to the Chief Executive of the Council outlining his background and his commitment, setting out his commitment to help with the rebuild of the stadium. More recently, Mr. Worley sent an email to SCS expressing his willingness to form a consortium with Mr. Hunter. He attached a copy of his latest filed accounts to that email. The The accounts show that Mr. Worley's company has a substantial turnover and profits and shareholder funds of 6.1 million. In summary, these two individuals, both managing directors of very healthy and profitable long-established businesses, are committed, given the opportunity, to reinstating Brandon Stadium. In addition to these credible individuals, it is apparent too that there are also many offers of financial or in-kind support from skilled trades who are familiar with current building regulations, as well as from substantial businesses who are prepared to assist with the recommencement of racing, including, I cite, West Midlands Golf Club, Mr. Thompson, who's the Managing Director of Wickham Blackwell Timber Engineering, previously MD of Build-Base Limited, whose sponsorship advertising boards are still evident at the stadium, the photographs, and Mr. Harvey, Managing Director of North East Demolition Limited. In summary, Mr. Hunter gave clear and uncontradicted evidence of his intentions regarding the purchase of the site, of his preparedness to fund the works necessary for the recommencement of the use, of his deep pockets, and of his resolve, and of his openness to work with the consortium. As to the availability of the appeal site for purchase, it will obviously be necessary to await the outcome of the appeal and the detail of the decision. Mr. Hooper conceded that if compulsory purchase had to be considered by the council because the landowner refused to sell, the market value of the site for which compensation would be payable might simply reflect the existing use value, i.e. on the basis that the site did not have and could not obtain planning permission for residential development. So compensation might indeed well be nil, given the existing use value would have to reflect, for example, the need for work to be carried out to the stadium and the need to pay for security. The current refusal to sell and the ongoing payment of £100,000 per annum for the security of the site would of course have to be weighed by the appellant against the compensation receivable for compulsory purchase. It is quite possible too that the appellant might decide, for example, to cut its losses and to seek to offset the loss, brackets the original price paid for the stadium, against a capital tax gains liability which would otherwise be payable in the then current tax year by other parts of the investing group of interrelated companies. That's just good accountancy practice and saves a lot of tax. As the cost of reinstatement of use, the SCS schedule and its basis was explained by Mr. Carter. SCS believed the costs put forward in Mr. Carter's proof, informed by Mr. Rees, Lestrade and Chapman, all of whom have extensive and relevant experience, are reasonable and would enable racing to resume on what has been referred to at the inquiry, if somewhat inaccurately, as a jumpers for goalpost basis. The appellant refers to the Farrow Walsh report. Its front page is dated April of this year, albeit the inside page then says the first issue was 9th of May of this year. Despite this date, it was only made available for the first time as an appendix to Mr. Hooper's proof. It was not listed as a document in the appellant's statement of case, which was submitted electronically with the appeal form, the latter being dated the 12th of May 2023. Quite apart from the late disclosure of this evidence, SCS have not been able to carry out, and for that purpose commission, any survey work as a basis to check and or question any of the findings of that report. The report states that the purpose of the survey was to visually examine the existing structural elements of the main grandstand terraces, and provide commentary on the structural stability, condition of the property, condition of the structural and non-structural walls, and determine the expected lifespan of the structure. The report was expressly limited in scope to areas which were not covered, unexposed or inaccessible. The report's author was not called to give evidence. The report describes the main grandstand as being constructed around 1920. It was, in fact, constructed in stages almost half a century later, as stated in Mr. Carter's rebuttal. So, one, some further caution is required before unquestioning reliance is placed on the document. Two, significantly, given this phased construction, it may, for example, be possible to demolish those areas of the grandstand most seriously damaged by fire, the northern end, the restaurant section, which is on stilts, and the southern end, i.e. the hospitality boxes and offices, leaving the central sections the subject to refurbishment. These are all suppositions, but they are possibilities. Both the restaurant area of the grandstand and the hospitality end of the grandstand were built as separate phases to the central section, as is clearly evident in photographs before the inquiry. The structural engineers did not address this possibility. The report may be said to give only a high-level picture based on external observation. The cost report, prepared by Ryder Levitt Bucknell, expressly relies upon it, so the cost report must be treated with similar condition. The cost report is dated July of 2023 and was again included as an appendix to Mr. Hooper's proof. Again, although July 23 in this case postdates the statement of case, the date of it, the documents listed in the statement of case were not updated by Mr. Hooper, and again SCS have not had the opportunity to commission a cost engineer's report. The cost report refers to a project which is not the proposal envisaged or advanced by SCS. In brief summary, and I just say C2 Appendix D, it proposes demolition of the grandstand and replacement with a 1,000-seater stand, together costing over £5 million, and reinstating facilities for greyhound racing. Yet none of these are proposed by SCS. SCS also note that the Farrow report does not expressly state that demolition of the grandstand is necessary. Mr. Osborne produced his what's known as CD 5-1550. He also assumed that the grandstand would be demolished. Mr. Carter, in his rebuttal of Mr. Osborne's proof, made reference to this assumption, stating that the structural report falls short of saying demolition is required, but accepted that it might prove to be necessary. An analysis of the evidence before the inquiry in respect of CD 1550 is set out in Appendix E. It submitted that it would be premature to conclude now that a viable return is not possible. SCS and others have not had the opportunity to investigate and survey the site in detail, and on a positive can-do, as well as, of course, regulatory compliance basis. Even if, and entirely without prejudice to SCS's case, even if it were to be found upon investigation that this stage 1 use were not possible, then that would still leave exploration of bringing forward as a single step a new stadium, and for that purpose seeking funding with a fully formulated business plan from supporters and grants from, for example, the National Lottery and from the Mayor of the West Midlands. It is notable that it was the Mayor who contacted SCS rather than vice versa. There is clearly real interest in seeing a properly functioning stadium again. There is in principle support from the Council too. As to the viability of speedway and stock car racing, Mr. Eadie's evidence was again seriously deficient. In oral evidence, he said, we've taken, this is during the session, we've listened back to the recordings, we've taken all the available evidence and data and used that in the absence of other information. The fact that data and evidence is limited, we've taken what is there and done our best with that to ensure that what we present, what we think is a realistic picture of the situation. Mr. Eadie did not provide any evidence of his own related to viability specific to Brandon Stadium, and instead stated, this report does not look to determine whether the now closed speedway track at Brandon Stadium was a viable enterprise, but is predominantly informed by consideration of sporting trends and analysis of consultation with and information supplied by other providers nationally. Yet when discussing national trends, the author states that attendances for either domestic or international events are not published and difficult to obtain, and goes on to say, as such, it's accepted in preparing this report, KKP is unable to provide a full picture in terms of trends. When Mr. Eadie referred to information supplied by other providers nationally, the only sources he referred to, the CEO of Gaming International, the owner of Swindon Robbins, the former chairman of BSPA, and the coordinator of the SCB. It became apparent that Mr. Eadie was unaware of who any of those people were, although he did accept that the owner of Swindon Robbins and former chair of BSPA are one and the same person, Terry Russell. In the SCS response to the original 2021 Speedway appraisal, it was pointed out that Mr. Russell had denied speaking to anyone regarding Coventry Speedway and had expressed his view that Coventry was one of the best supported clubs in the sport and could operate successfully notwithstanding the current economic challenges. Similar, SCS pointed out that Mr. Vatcher, the current SCB coordinator, had no recollection of conversation with KKP. Moreover, and again a point made in the SCS response 2021 appraisal, Mr. Eadie, or rather the author of the KKP reports, does not attribute any of the content of the report to any of the individuals referred to. Despite making this point, the updated appraisal simply does not attribute any of the comments to any of the individuals. In the absence of attendance figures from any track other than the Arena Essex, Mr. Eadie referred to attendance figures at that venue. These figures, which indicated attendances had fallen to an average of just 340 in 2017, appeared in the Arena Essex planning application and were copied along with swathes of other evidence and pasted into the original KKP appraisal in the section entitled National Trends. In response to the original appraisal, SCS pointed out that the fall in attendance was not surprising, as Arena Essex in 2017 had dropped down to the National Development League, and further expressed significant concern that so-called evidence had simply been copied from the undetermined Arena Essex application and then been presented as representing a national trend. Despite pointing this out, the Arena Essex information was reproduced in the updated 2023 appraisal without any caveat at all. It may be observed that Mr. Osborne had been Swindon Stadium owner for many years and Poole Stadium operator also for many years. As such, his staff managed the turnstiles at both venues, and the appellants had every opportunity to produce figures to demonstrate a decline, if such were true, in attendances at those two venues. It is first important to look at the past evidence. The evidence suggests that Speedway and stock car racing was viable at the time of the appellant's acquisition of the site from the then owner, Mr. Sandu. Mr. Rees mentioned the significant investment that Mr. Sandu had made in the stadium since becoming owner in 2003. The documentary evidence before the inquiry also suggests that the enforced sale of the stadium to the appellant in 2015, by the bank that is, was related to Mr. Sandu's other business interests alone. Mr. Horton also ran Speedway racing viably, even taking into account the repayment of the price paid for the acquisition of the Speedway promotion rights from Mr. Sandu from 2012 to 2016. Mr. Sandu retained promotion rights for the stock car racing until closure. Despite the guest Wilson, that's the accountant's letter, and Mr. Horton's accounts being in evidence, Mr. Eadie made no reference to either. Mr. Carter gave evidence as to stock car attendances and referred to Speedway attendances at Brandon in 2016. This is discussed further below, but it is consistent with viability at the time both for the promoters of racing and for the stadium. This was the conclusion also of Mr. Allen in WYG's report to the Council in 2019. Quite apart from the attendance figures for 2016 referred to for Brandon, Mr. Carter has particular experience of stock car racing, including its governance, as well as regular attendance at tracks throughout the country. Mr. Ford, as I've said, is a successful Speedway promoter at Poole. This seemed to be common ground, and both he and Mr. Hunter are keen to come together at Coventry. Mr. Ford had no doubt that he could achieve a profitable return of the Coventry Bees, starting in the Championship League. He has 30 riders contracted to him, he told the inquiry. This is plainly more than sufficient to service both Poole and Coventry, because each would have a team of 7 riders. Mr. Ford referred to the need for some 1,200 spectators attending Speedway events at Coventry. Given the level of attendance of both Speedway and stock car racing at Brandon in 2016, this does not appear to be unduly optimistic. Indeed, it also sits well below any bounce in numbers, the uplift you might get because it's a new attraction in the first season. Mr. Ford did not accept the notional profit and loss data prepared by Mr. Osborne with input from Mr. Park in relating to Speedway. He said that he'd been told the figures provided by Mr. Park, who is associated with Swindon Speedway, related to the Swindon venture. Although Mr. Osborne said that there had been a discussion with Mr. Ford's son, perhaps on the same basis, Mr. Ford clearly still actively runs the business side of Poole Speedway. He has given oral evidence to the inquiry and been cross-examined, so you've had the benefit of seeing his demeanour and listening to his evidence and his cross-examination. Mr. Rees also expressly referred to and acknowledged Mr. Ford's integrity in his evidence to the inquiry. Mr. Osborne referred to figures related to stock car racing, stating that the source of those figures was Craig Robinson, Mr Robinson's involvement with stock car racing is not on an affiliated Brisker or Orkey basis, so is not regulated by the governing bodies. Mr Osborne referred in his written evidence to the costs of staging a meeting, including prize money, staff and first aid ambulance attendance, as being between £4,000 to £8,000, and the admission price being £20. He also referred to additional revenue streams from which the promoter benefits: local sponsorship, programme sales, merchandise sales and video streaming. In addition, he referred to income from food and beverage sales. These figures were, and are not, disputed by SCS. Where SCS disagree with Mr Osborne's, Mr Robinson's figures is as to the level of attendance. The suggested figure of 600 may be appropriate to non-regulated stock car racing, but it's not accepted that this would be appropriate for mainstream stock car racing at Brandon, Coventry. Mr Carter's evidence was that stock car attendances at Coventry averaged 2,500 in 2016, and 3,500 if the attendance at the World Final were included in that average, and that 765 different drivers competed that year. For Speedway, 170 different riders competed that year, and the average attendance was 1,700. The consistency of this with the viability of both racing and the stadium has been noted above. Under cross-examination, Mr Carter stated his source for Brandon as the turnstile manager and offered to provide written data. Mr Rees also confirmed the attendances, 3,000 at Odsall in Bradford, and the rental levels, £3,500, achieved for the stock car meetings he had promoted at Brandon. None of these figures were disputed. Gate receipts alone, resulting from attendance levels given in evidence by Mr Carter for Brisker Formula One events, offset by the costs of staging a meeting, demonstrate the viable nature of stock car racing. It's not surprising, therefore, why stock car racing ran along Speedway at Brandon for 62 years. And at footnote 61, I just give the figures there, just a very crude example, why the revenue would more than meet the costs of staging the meeting by Mr Robinson on his basis. Back to 98. As to the notional profit and loss data, Mr Osborne recognised that it was, I think it was his word, an amalgam, and assumed that the stadium owner was also the Speedway promoter. Notably, the assumed attendance figures are too low. Plainly, if higher attendances are achieved, a positive cash flow will result for the Championship League alone. Well, that's where there was a negative cash flow of about minus 3,000. Mr Ford gave evidence as a considerably higher level of sponsorship and sales of merchandise achieved by him at Poole. These two items alone would provide more than a 20% return on the total cost set out in that document. And thirdly, the profit and loss document does not include the revenue from stock car meetings, nor any sharing of costs of stock car racing. In conclusion, it is considered as a real as opposed to theoretical possibility that it would be financially viable to reinstate the Speedway Stadium both in the short and or long term, and for Speedway and stock car racing to be viable. Issue 4, whether there is an identified need for the alternative sports stadium provision proposed. Whilst the Council's note on 3G pitches states that the playing pitch, which we've now received in evidence, that the playing pitch, I thought it already got to you, madam, but anyway, whilst that suggests that the playing pitches strategy of 2015 has borne some fruit in terms of provision, there appears, and we don't purport to be experts, to be a quantitative need in Rugby Borough as a whole, and also in the Coventry City as a whole, for more full-size 3G pitches. But it has not been shown that there is a qualitative need for that pitch to be on the Peel site. It lies outside the urban areas of Rugby and Coventry, and it does not fit with the express locational aspirations of any of those clubs contacted. Both the Football Foundation and Birmingham FA have stated that they believe the location of the proposed pitch may be too rural to attract sufficient demand, and Sport England do not support it. Moreover, if the result of providing full-size 3G pitch on the Appeal site will lead to the demise of the Woolston Leisure and Community Centre, it may be said that there is a need not to grant planning permission for the proposed 3G pitch at Brandon. The impact on Woolston was not addressed or assessed in the officer's report to committee. And we've had to just pause it we've had that discussion this morning about 3G pitches. When one looks at that business plan, and again, it's assumed it's going up to 10 o'clock, will it be reduced to 9:30? All the assumptions there, we have serious concerns as to whether it will be viable. We come on to that under 5, which is whether the benefits of the alternative sports provision outweigh the loss of the former speedway use. When considering the respective benefits and losses, it's appropriate also to consider the viability of the alternative sports provision proposed. As regards the 3G pitch, the evidence set out in the July 2023 feasibility study raises doubts about the future viability of the 3G pitch. The study recognises that if another pitch were to come forward, whether before the proposed 3G pitch is brought into use or after it has been, the viability of it could well be affected. It's noticeable, we may not get to year 10, it could be year 2 or 3. It is noticeable in this regard how the views of consultees have already changed between 2021 and 2023. Simply looking at the 2023 study, of the 10 clubs approached, 9 responded, only 5 expressed an interest, all 5 are located in closer proximity to existing pitches. 3 of those 5 have aspirations to use other 3G pitches should they come forward. The remaining 2 of the 5 comprise 27 teams in total. Sky Blues in the community have made it clear, moreover, that they have had no input as to the programme of use or the costs of projections outlined in the business plan. SCS believe that 4 of the 5 clubs who expressed an interest are beyond the 5-mile catchment area referred to by Mr. Eadie. In the case of St Finbarrs, it was pointed out by SCS in response to the 2021 KKP appraisal that it was 10.2 miles away, and my footnote 69 notes that our what's now CD 18.21, our response to CD 18.10 put in by Mr. Hooper last Tuesday, the distances to football clubs, and it explains the difference there. The consequences of failure must be borne in mind. Planning permission would have been granted on the basis of benefits to which too great weight had been given. By contrast, if it were to be found that reuse of the appeal site for racing were not in fact viable, that would not preclude a future reconsideration of the site. Whereas the housing development, if built, is likely, of course, to preclude any possibility of racing in perpetuity. And as Sport England has observed, it would be harder to achieve the relocation of the current use to an alternative location than to provide a 3G pitch elsewhere. I have already addressed the issue as to whether speedway and stock car racing are in terminal decline. As to the respective number of participants, whilst the 3G pitch may, fully utilised in accordance with the POU, give rise to 1,200 participants a week, it's important also to bear in mind that the number of participants in racing is not insignificant. I've referred above to Mr. Carter's evidence about the 170 different speedway drivers and 765 different stock car drivers racing at Brandon in 2016. I note they don't include mechanics, etc., those behind the respective driver or rider. And many drivers and riders race at multiple events. It's not just Brandon. The total number of participants and spectators at the stadium during 2016 can be estimated as follows. And I simply take the material that we've got: 37 speedway metres in 2016, 14 riders, because 2 competing teams, gives you the 518 riders. I look at the stock car racing, the 9+7 events, times 150, that's 2,400 drivers. The stock car spectators, both for Brisker F1 meetings and the World Final, then stock car spectators at other referred to as Star Tracks events, and then I also factor in the spectators at the 17 Coventry Bees Speedway events, the figures there, and that gives over a year 73,818 per annum sport and recreation experiences in 2016. Compare the 50,000 per annum for the 3G facility. So, okay, it's a rough and ready, very crude analysis. It can't be assumed that you're going to the benefit completely dwarfs the benefit of Speedway. In fact, it looks as though it could be the other way round. Point 6, other benefits of the proposal including the delivery of new market and affordable housing. SCS take the view that the benefits have been overstated by Mr. Hooper. Indeed, his apparent conclusion that every benefit is to be given substantial weight indicates with respect to lack of balance, quite apart from failure properly to reflect the relevant legal and policy framework. The delivery of market homes, well, I've referred to that in my opening, I won't repeat it, but only modest weight, SCS feels, should be given to this. There is a 5-year supply. The local plan is delivering at least in accordance with its policies. In particular, the uplift in delivery since 2018 accords exactly with the local plan inspector's intentions. Whilst the figures are not ceilings, fully accept that, there is no need to develop the site. The most recent assessment of the 5-year housing land supply and dwellings completions provide additional comfort for this view. Mr. Hooper has referred to the existence of a joint venture agreement between Investin plc and St Phillips Limited in respect to the development of the site. It is accepted on this basis that a development may therefore proceed despite the warning and recommendation received from CBRE's report, which worked on the assumption that there would be a 25% discount to open market value for the discounted market sales housing units. No reference is made in their report to social rent or shared ownership, only to discount market. Mr. Hooper's latest note refers to rents not exceeding 80% of local market value for affordable rent dwellings, and we had the figure 75%, I think it was, for the shared ownership today. Just taking that 80% of market rent does not constitute a social rent with a registered provider, and there's no guarantee that the percentage will be less than 80%. Secondly, despite requests, we've now been told that when I wrote this, the position vis-à-vis shared ownership had not been clarified either. You had to ask that this morning. It appears at present that the affordable housing provision may simply become discount market sales not involving a registered provider. And the Section 106 appears to facilitate this. I've heard what's said about in relation to Section 106, but it's when one comes to the detail of the affordable housing provision, its nature and what's required, that it's rather borne out. Secondly, the delivery of affordable housing. The foregoing calls into question the claimed benefits of the affordable housing. By way of introduction, the need for affordable housing in the borough is not in dispute. It's well known nationally that there's a need. Its provision is a policy requirement of the local plan and of government policy. It's incorrect to regard it, given the wording of the local plan, as only a benefit. And it is a requirement of the local plan. You can give weight to that, but the first point is requirements. It can also be a benefit and give weight to that, but it's not just simply a benefit. Irrespective of the nature of the affordable housing that may be delivered, SCS consider that the 10-year split proposed by the appellant has not been justified. The council could not explain what justified the change from the SHMA's 86-14% to 56-44, other than that there is said to be a significant lack of demand for social rented properties in rural areas. If there is a significant lack of demand, then why is any being provided? Given, however, that the more recent, if not fully examined Hedner continues to seek a similar percentage split to that in the SHMA, it would appear that there is indeed a significant demand. So why is the proposed provision sufficient in terms of percentage? Why isn't it higher? Why isn't it up to the 86-14 split? In addition, the affordable housing mix, in terms of the number of bedrooms, does not accord with policy H2. The Hedner suggests a mix comprising 70% 1- and 2-bedroom properties. No 1-bedroom properties are proposed. It's unclear why these are not appropriate in this location. The number of households on the housing register, referring to Binley Wood Civil Parish or Brandon and Brentford Civil Parish as at 20th September 2023, the local authority provided a notice at the beginning of the inquiry, were respectively for 29 and 19 houses. Just leave the 411 for a moment. Yet applicants are encouraged to specify as many locations within Rugby Borough as possible. And the inquiry was informed by the relevant council office at the Affordable Housing Round Table that a significant number of applicants have expressed a wish to live in more than one area. So one, it cannot be assumed that the 29 or 19 wish to live in the vicinity of the appeal site. Two, Mr Carter gave evidence that the nearby sites at Sherwood Farm, just down the road, in Woolston, have yet to fill affordable housing, respectively 24 and 11 homes, to serve the current shortfall locally. More generally, and that's the housing register for the borough as a whole had 411 on, just corrected that, but it's been in the wrong place. More generally, H1 does not require the provision of 171 dwellings each and every year. The number, or that number, is an annualised average referred to in the SHMA, but it's not a policy requirement in the local plan. The local plan envisaged that the plan would meet all affordable housing need in Rugby Borough, no doubt in part because it was also making provision to meet 2,800 homes needed by Coventry City in Rugby Borough. So it's meeting far more than the needs of Rugby. The local plan also envisages, as did the local plan inspector, that there would be a step change in the housing requirement from 2018-19 until the end of the plan period in 2031. Mr Stacey's figure 1 shows the immediate positive impact in terms of increase thereof, not only on market housing delivery, but also, unsurprisingly, since the two are linked, affordable housing delivery. Mr Stacey referred to the figure of 495 affordable housing dwellings per annum in the Headner, but recognised that this was not a planning figure. Mr Carter pointed out the obvious impracticality of using such a figure for planning purposes. The future figure is appropriately to be considered and addressed through the forthcoming local plan review. Mr Carter takes the view that the relevant figure is 171, that's net of demolitions, rather than in addition after subtraction to reflect the exercise of the right to buy. There is no reason to suppose that that figure will not be achieved over the planned period as anticipated by paragraph 514 of the local plan and as envisaged by the local plan inspector, especially since the 20%, 30%, depending whether it's brownfield or greenfield, became the relevant, i.e. lower percentage requirements for affordable housing following the examination. Since, moreover, 171 DPA is not an annual requirement, it would be inappropriate to take a Sedgefield as opposed to a Liverpool approach to making up the current shortfall. None of the foregoing is to suggest at all that affordable housing is not needed. It's to suggest that the weight to be given to this issue in this case is moderate, and in any event is not sufficient to justify the development of the appeal site. Only in context, not obviously any affordable housing gives weight to that, but only 25 rather than 125 homes can be generated from this site. New homes bonus, the third benefit referred to, I think, by the appellants, this should not be given any weight because it's not needed to make the development acceptable. Fourth, it was claimed there would be a 370% increase in open space. That the provision of that open space is to be secured by the Section 106 obligation. Over-provision cannot, in my submission, be given any weight. It's not necessary to make the development acceptable. It cannot in law be a reason for granting planning permission. This is to avoid the buying and selling of permissions. And I've just referred at footnote 87 to the other case, I think it's the last case of DB Symmetry in Swindon Borough Council last year, where that case, it was on a different point whether a planning condition could require the dedication of public rights of way over land. But the Supreme Court also considered the scope of Section 106 agreements and what could lawfully be taken into account. I just refer to paragraphs 55, 60, 62, and in essence, government policy and the law have rejected the buying and selling of planning permissions, where a local planning authority makes exorbitant demands of a developer, or a developer offers planning gain which is not sufficiently related to its proposal in the hope of obtaining planning permission. So if it's more than is necessary, and I also, it refers to Regulation 122, the SIL regulations. So it's very important that one doesn't fall for the trap, which is very easy because we're outside the law's reaches often at these inquiries. Someone says, oh, there's a great benefit here, but that goes beyond what is necessary and the requirements. You cannot, if it's secured by 106, it cannot be a reason for granting permission. Therefore, you can't, one cannot give it weight. Yes, it's if the appellant wants to enter into 106 or any other agreement, freely making provision, that's a choice for the developer. But it's not something to which weight can be given because of Regulation 122. And the same tests apply, of course, for conditions, because it's paragraph 56 of the MPPF. That's a policy test, but anyway, it's still relevant to this inquiry. Economic benefits, these are accepted and may attract modest weight, but they need also to be tempered by the economic benefits which would arise from the resumption of speedway and stock car racing, from the reintroduction of racing and stadium reopening. 3G pitch. First, if contrary to our submissions, the appellant were to be successful in demonstrating that MPF paragraph 99A is satisfied, the benefit of the 3G pitch secured by the 106 should not in law be taken into account, since, as I've just said, it would not be needed to make the development acceptable. Secondly, I've addressed this issue above, and only limited weight should be given to it, given the views of Sport England, the concern of Wilson Community and Leisure Centre, and the distance to the appeal site from many of the clubs which it hopes to serve. Thirdly, factually, the playing pitches strategy has borne some fruit in the form of 2 3G pitches. Issue 7, I needn't trouble with education. 8, the overall planning balance. I refer to the well-known Section 38(6), obviously important legal framework. We say that the proposed development does not comply with the development plan as a whole. Material considerations do not indicate that the determination should be other than accordance to the development plan. The MPF, the development plan, is not out of date, and a 5-year supply of deliverable housing sites is accepted. It's not a tilted balance case, therefore, and indeed the tilted balance does not apply in any event in respect to development that conflicts with Greenbelt policy. The benefits have been set out above and analysed. As to the harm, plans, there will be harm to Greenbelt, very special circumstances not shown. Secondly, the failure to satisfy paragraph 99 of the framework concerning the importance of open space and recreation, and the loss of a revered stadium used for speedway and stock car racing for many years. Thirdly, irrespective of the stadium buildings, the appeal site as a place should, SES believe, be considered a non-designated heritage asset by virtue of that treasured association with speedway and stock car racing. All we'll be left with is Speedway Lane as a memento, the name. The proposed development would result in the total loss of the heritage asset. MPPF paragraph 203 sets out the relevant test. I won't repeat that. The fact that the council did not refuse permission on this basis does not preclude the matter being raised by SCS or from succeeding on this argument. The council does not have a local list, so it cannot be said to have applied its mind to this issue before. Fourthly, the loss of 3 oak trees, the subject of TPO, also affecting characteristic landscape feature. And fifthly, housing mix, non-compliant with policy, and lack of justification for this or for the percentage split between social rent and intermediate housing. Indeed, a clear possibility that discount market sales only will result. So I say it's respectfully submitted the appeal should be dismissed. I just add one postscript. That's all I'm just the. It's pertinent, firstly, to note the importance of the inquiry to SCS. I'm sure it's important to the appellants, the council as well, but to SCS, not only because they're dismayed at the prospect of the loss of the appeal site to speedway and stock car racing, but also because so many of the points made in their previous representation had not and have not been addressed by the appellant. The appellant's proofs of evidence associated with reports of inquiry have reflected this approach. The opportunity afforded by Rule 6 status to be heard and to cross-examine witnesses is vital to the proper function of the planning system. The amount of work diligently undertaken by SCS over some 9 years now is remarkable, from attending the initial public exhibition concerning a proposal for 250 dwellings in 2014, a subsequent public exhibition in 2017, making representations to and appearing at the local plan examination, which secured current local plan policy HS4, making representations to the neighbourhood development plan examination, which secured current policy LF1, making representations in response to the 2018 application, including a detailed response to the sports need assessment prepared by Framptons, engaging with WYG, independent review supporting our contention that the site is not surplus to requirements, making representations in response to the substantial revisions to the planning application in 2021 and to the officer's original subsequent withdrawn report committee. Only council members have fully appreciated SCS's concerns, and the position is supported by people from 44 of England's 46 counties and from 14 countries, looking at all the written representations where they've come from. Much of the foregoing has taken place over those 9 years or so, of having powerlessly to watch the buildings on the site deteriorate as a result of antisocial and, of course, criminal behaviour of trespassers, without proper steps being taken to prevent this. For Mr. Hooper to state in his proof that the appellant had, in all the years since the enforced closure of the site by the appellant, done all that it could to secure the site, in the teeth of the convictions for the appellant's failure to comply with the community protection notice, is as offensive to SCS as it is inimical to the rule of law. It is simply not permissible to seek to imply that though the appellant has not pursued an appeal against the convictions, fines or order of costs, it was not guilty of the offences. Thank you, madam. Thank you very much.
Thank you very much, Mr. Humphreys. Right, bearing in mind we are now on 1:10 I think we'll now have a lunch break. We'll take the full hour. We'll come back at 2:10, if that's all right with everybody. Okay, so we'll adjourn then until 2:10, and then we'll have the closing submissions from the council. Thank you very much. Everybody, we are now resumed. The time is just gone 2:10. So we're now going to hear from the council with their closing submissions. So over to you, Mr. Richards.
Thank you very much, Madam. Good afternoon, everybody. These closing submissions should please be read as following on from those in the council's opening statement. Repetition is avoided in the interests of brevity. At the close in the inquiry, the council resolves from nothing said in opening. We will consider each main issue in turn. Main issue 1, the Greenbelt. The key planning policy route map and judgments are, firstly, the Rugby Borough Local Plan, Policy GP2, refers the reader to National Greenbelt Policy. The Brandon and Bretford Neighbourhood Plan, Policy H2, supports redevelopment of previously developed land subject to there being no conflict with National Greenbelt Policy. NPPF, Para 149G, provides that redevelopment of previously developed land is not inappropriate development if it would not have a greater impact on openness than the existing development. And NPPF Para 149B and 150 support the use of the Greenbelt for outdoor sports and the provision of appropriate facilities for outdoor sports, as long as the facilities preserve the openness of the Greenbelt and do not conflict with the purposes of including land within it. The application of these policy tests calls for planning judgment. The council regards the car park as being within the curtilage of the stadium, and therefore the whole site is previously developed land. The officer report placed much emphasis on the comparative coverage plan, which it said shows 4.35 hectares of existing built coverage, while what was proposed was 4.1 hectares, and at a smaller scale. Mr. Stevens, in his paragraph 4.6, agrees with the analysis in the officer report. That agreement is reflected in the Statement of Common Ground. Mr. Carter, for SCS, disagrees. He finds a substantial adverse impact on the openness of the Greenbelt. He puts a greater emphasis on the visual effect on openness than the council, and notes that planning permission was previously refused for a Sunday market on the car park on the Greenbelt openness grounds. His approach examines the footprint of built development and finds it will be 33% greater with the appeal scheme. Your task, Madam, is to consider both approaches and to reach your planning judgment. If that is Mr. Carter is preferred, then the appellant will have to demonstrate very special circumstances to bring the development within national and therefore local Greenbelt policy. This matter is not canvassed in the proofs of the appellant or the Borough Council, I add, for obvious reasons. So, main issue 2, surplus to requirements. It's common ground that the loss of the stadium falls to be assessed against paragraph 99 of the MPPF, and that the wording of what is now paragraph 99A has remained consistent since the first edition in 2012 and subsequently. The paragraph numbering has changed. Para 99 was para 74 in 2012. What is now a 99A case was originally advanced in the Speedway and Stock Car Needs Assessment October 2018, and it referenced the Sport England Assessing Needs and Opportunities Guide, ANOG, 2014. Frampton's, the authors of the assessment and the appellant's then planning agent, concluded that the then paragraph 97A test was satisfied. The council instructed WIG to independently review the application. WIG's report in September 2019 concluded that the 97A test was not meant, but suggested that a way forward might include a consideration of 97B or 97C. This conclusion was not disputed at the time by any of the parties, and the original planning application did not seek to argue that the stadium was surplus following this review. In 2021, amended application documents and plans were submitted. There was no new or updated needs assessment. The planning statement summarised the difficulties hitherto with making out a sufficient case under 97A, and instead switched strategy to making out a case under 97C. However, Para 448 appears to keep a 97A case alive as well as introducing one under 97C, while Para 628 addresses viability. Para 630 discounts 97B. Para 635 confirms that an alternative sports provision, i.e. 97C, is the only way, the only means by which the policy requirement can be met. It's quite clear, therefore, that the 97A case or route was not being pursued. The final sentence of Para 636 shows that the appellant was putting all of its paragraph 97 eggs into the 97C basket. The appellant's statement of case expressly references 97C. However, Para 417 references 99A, but in the context that redeveloping the stadium would not be advisable, based, no doubt, on the earlier assessment that it was not viable to do so. Viability is not part of a 99A assessment. It's a separate material consideration. The stadium might not be surplus to requirements, but it might not be viable to recommence speedway or stock car racing. The two are separate and cover different main issues in this appeal. However, in this inquiry, the appellant continues to rely on paragraph 99A, and the council's evidence addresses it. Under 99A, the stadium site should not be built on unless the appellant clearly shows it is surplus to requirements. One then looks to see if there is any authoritative guidance or further explanation as to what surplus means or how to assess it. The Sport England ANOG is, so says Mr. Allen, a how-to-do guide. It promotes a staged approach. Stage B looks at quantity, quality, accessibility, and availability or provision. At paragraph A9, we are advised that NPPF paragraph 74 cases should be considered under the headings of the guide. Sport England plainly have expertise and experience when it comes to assessing need for sports facilities, and they are the government's agency and are statutory and non-statutory consultees in planning matters. Mr. Eadie is of the opinion that ANOG is only applicable to participation assessments and not to spectator facilities. Mr. Allen and Sport England themselves say it is applicable in this case, as it makes no sense to separate participation and spectating, particularly where, as in this case, the riders are participating in what is essentially a spectator sport. Mr. Eadie accepts that the methodology of the ANOG guidance is appropriate in the absence of any bespoke spectator facility guidance. That being the case, we submit that the following principles derived from ANOG must be relevant considerations in the surplus to requirement assessment of the stadium. The importance of the role of the national governing bodies. The importance of links with the local priorities set out in neighbourhood plans. The need to consider the supply issues of quality, quantity, quality, accessibility, availability. That the fact that a facility is not in current use does not itself indicate a lack of need. The key aspects of quality include its condition and, of course, it is necessary to be precise as to the initial purpose of a reopened stadium. Availability. In this case, it was the owner's decision to cease the use of the stadium for sport. It's quite clear that the current owners have no intention at all in allowing such a use to resume, at least not until its prospects of realising housing land value have rescinded. Demand. There's a clear demand for Brandon Stadium set against the ANOG demand indicators: current demand, future demand, latent demand, and displaced demand. Participation at the stadium is being restricted, suppressing or displacing demand. Current demand is clear from the SCS evidence to the inquiry. The Speedway and Stocks calendars are able to be expanded should racing be able to resume to meet future and latent demand. It's inconceivable that if that happened, spectators would stay away. Indeed, the experience at Oxford suggests that they would turn out in force. The outcome of applying such principles in the context of an assessment under NPPF paras 98 and 99 is likely to be a robust and up-to-date assessment of need. A failure to do so by the appellant makes its evidence less than robust. There is no mention at all in ANOG of viability. This suggests it is a separate material consideration to the paragraph 99 exercise. So far as local plan policy is concerned, policy HS4C means that the stadium site should not be built on unless one of three exceptions is made out. The first mirrors NPPF 99A, the second does not apply on the facts of this case, and the third largely mirrors 99C, save that where the NPPF references benefits, HS4C has needs. Under Neighbourhood Plan Policy LF1, the loss of a community facility, which expressly includes the stadium, is only acceptable where it is no longer needed or viable. So what does surplus to requirements or no longer needed mean? We submit the position is reached where there is no need, having considered supply and demand and consultation responses from relevant stakeholders such as sport governing bodies, promoters and the fan base. In terms of stocks, the stadium had national importance. In terms of speedway, it is now regionally significant, both because of the former achievements of the Coventry Bees and because of the diminishing number of venues in the Midlands, and the West Midlands in particular. It's important to remember why racing did cease in 2016. The then owner had other business loans secured against the stadium. When these were called in, the bank effectively forced the sale of the stadium. The current owners have shown no interest in resuming racing. They simply want to achieve the development value of the land. That is why they took advantage of the forced sale and purchased it. Hooper's assessment that offers to purchase the stadium were below financial expectation shows a mastery of understatement. We say there is still a need or demand for speedway and stock car racing. Locally, this is manifested by the SCS campaign group's endeavours over the years, and certainly since 2018, when the planning application was made through to this inquiry, spearheaded by King's Counsel. All this would be very odd behaviour from a group of people if they did not hold a firm commitment to resurrecting the motorsport use of the site, given the opportunity. Second, SCS has secured backers. We say Mr. Hunter's background in stocks, his deep pockets, his efforts to buy the stadium so that his son can win there as he did, and his willingness to rent the stadium to Mr. Ford, who has a successful promotion background, is all further evidence as to the credibility of the local campaign to deliver, should they be given the opportunity to do so. Plainly, the SCS business plan is based on the best available evidence. The appellant has not allowed them onto the site itself to make any form of detailed assessment. But there are examples of recent reopened speedway venues at Oxford and Workington, which SCS has drawn on. In the face of all this, the response of the appellant is, effectively, well, we won't allow it. Insofar as availability is a factor to be considered, which it is, see ANOG, then the site is simply not available. We make two obvious points in response to this wholly unattractive position. First, that attitude should not be given significant weight, even if it is genuinely, as opposed to tactically, the position. Second, once the appellant realises that the planning system acts in the public interest, not theirs, then they will seek to achieve a return on their investment within the constraints of the planning system and talk with motorsport promoters and enthusiasts. SCS would be at the front of the queue to speak with them. It is obvious that SCS should be given that chance before the stadium is declared to be surplus to requirements and planning permission granted for some other use. But even the reason given by the appellant for regarding the site as surplus does not withstand scrutiny. Mr. Hooper says there is no need to retain the stadium, it's therefore surplus, on the basis of the viability of Speedway as a sport as a whole. Speedway is not on its knees. It may not be in as rude health as in its 1970s heydays, but it is responding to contemporary challenges. There are positive indicators identified by Mr. Allen. It remains a professional sport with 3 functioning leagues, all with sponsors. Despite track closures, there is a new track at Workington and a reopened one at Oxford. The statement from Oxford shows it is thriving, and that has not been gainsaid by the appellant. Coventry Bees is in a good place to reform under promoter Matt Ford. BSPL confirmed this position in principle. Coventry was and remains one of our most important venues, both as a league racing outfit and also as an appropriate stadium for major events. Were it to become available again, there is absolutely no doubt that it would host top-level professional racing, and there is every expectation that it would again pull in some of the highest crowd numbers in the sport. The Premiership League is in a stable condition. Swindon closed under pressure from developers, but in any event, the appellant's agents are looking for a new site, which must demonstrate their confidence in the sport as a whole. The Essex Arena case is not a true parallel. The views of the sports governing bodies are rightly optimistic and positive for the future. The evidence of Mr. Philip Morris, both in writing and to the inquiry, was, we submit, impressive. His experience of riding in, coaching, and now leading and governing British Speedway makes him Mr. Speedway so far as this inquiry is concerned. His evidence is compelling. To borrow a metaphor from another sport, King's counsel for the appellant barely laid a glove on him. It is clear Speedway is not a dying sport. It is changing and adapting, but still needs stadia in which to race. Adapting to new broadcast media, adapting to the challenges of climate change by promoting new fuels, resisting on-track betting, adapting as teams lose their home tracks through no fault of their own, navigating the perils of COVID without any real government support, celebrating the successful reopening at Oxford and hoping for the same at Brandon, developing youth and female participation and opportunities, building on the family-friendly and police-light reputation of the sport, innovating in the face of rising costs, supporting and working with those like Mr. Osborne, who wants to deliver improved infrastructure in Swindon, sympathising with those at Wolverhampton who are turfed out by their landlords after 95 years, and working with those in difficulty such as at Bellevue and Ipswich to secure record ticket sales. In the event that the appellant's submission that paragraph 99 of the framework has no relevance to spectator facilities like stadia, then there is an alternative policy and analysis under paragraphs 92 and 93. The stadium is a place which promotes social interaction and is a valued social, recreational and cultural facility. Planning decisions should plan positively for such facilities and guard against their unnecessary loss and retain them for the benefit of the community. So on the facts of this case, these policy outcomes can be secured if a similar approach to that in paragraph 99 is taken. So for all these reasons, we say it's clear that the stadium at Brandon is not surplus to requirements. Main issue 3, financial viability. This issue does not go to MPPF 99A, but it does to Neighbourhood Plan Policy LF1. In reality, it's more relevant to main issue 5, do benefits outweigh the loss? Upon reflection, we do not believe that reinstate the Speedway Stadium is the correct question. Rather, it should be recommence use of the stadium for sport and recreation. That is what SCS's short-term plans amount to. This issue will be resolved on the evidence from the appellant and SCS. We say that Para 99A and LF1 both require the appellant to demonstrate that what SCS proposes is not viable, rather than for SCS to show that it is. Further, we submit that assessing viability in this context is not an exact science. It requires a good deal of judgment. We note that the KKP report concluded that assessing viability of Speedway as a sport and at Brandon is challenging. Whether or not a proposal is viable will depend, amongst other things, on the costs of bringing the site into a fit condition physically. SCS are in difficulty here because the appellant has declined to allow them access to the site in order to inspect its current condition. The appellant's evidence all goes to a full restoration of the stadium, when SCS has long been clear that this is not what it contemplates initially. What is proposed, so far as the stadium is concerned, is more akin to a phased return. Such an approach appears to be successful at Oxford. The appellant has not explained convincingly why it could not be the same at Brandon. Secondly, the cost of operating or hosting events. Here, SCS and its supporters are at least as knowledgeable and experienced as the appellant. The income likely to be generated by events. Again, SCS has knowledge and experience to draw on. It's reasonable to conclude that events are likely to be well attended and that the reopening of the iconic Brandon Stadium would be likely to attract sponsorship and broadcaster interest. And then the return on investment required in the short, medium and long term. Mr. Hunter is plainly in it for the long haul. His philanthropic approach suggests no real short-term pressure. The omens for Brandon Stadium are thus promising. It certainly cannot be said that it is not viable, or that there is no real prospect of viability being improved. If the physical condition of the land is an obstacle to resuming racing, then it is pertinent to ask, who is responsible for its deterioration? The answer is plain to see. The lack of proper site security was the cause of the nefarious intruders causing damage. This caused the council to serve a notice and to prosecute for its breach. The appellant was convicted. It lodged an appeal. But since the appellant then also took steps to properly secure the site, which was, after all, the council's purpose in serving the notice, the parties agreed to drop hands. The appeal would not be pursued, and the notice would be withdrawn. But that does not alter the fact that the appellant was and remains convicted, and was ordered to pay the council's legal costs. We say that is highly relevant to the weight that should be given to any conclusion by UMAM that site restoration costs make resumption of racing unviable. We say it justifies very much reduced weight. It's not a matter of law or rationality. It's simply a matter of planning judgment. There is no express policy support for it, but that is and never has been a barrier to identifying and weighing material considerations in the planning balance. There is policy support for the principle in paragraph 196 of the NPPF in the context of neglect to heritage assets, but there is no reason why the same principle should not apply to the stadium, whether or not it is a non-designated heritage asset as SCS advance. Mr. Hooper comments that the Council's resolution of the 14th of December 2022 has not been progressed or further acted upon. That is not surprising. The Council expects to win the appeal and thereafter that the appellant will either seek to realise a return for racing at the stadium or allow someone else to try by selling the land or granting a lease. In either case, the contract could contain provisions relating to the surrender of a lease or the buying back of the land in the event that racing was not being carried out on the site for whatever reason. If racing cannot be made profitable or sustainable, then the appellant should enjoy the benefit of the redevelopment value of the site. But that time is not now, and now is not the time for the council to be contemplating what action it might take or powers it might use in the event that the appellant stubbornly refuses to engage with reality following the dismissal of this appeal. Main issue 4, whether there is an identified need for the alternative sports provision proposed. This issue is relevant to NPPF para 99C and to Local Plan Policy HS4C, third exception. What is proposed is a single, full-sized 3G pitch with appropriate infrastructure such as fencing, lighting and shelters, and a clubhouse pavilion of a minimum footprint of 350 square metres with parking. The Council accepts that there is a current and continuing need for at least one 3G pitch in the borough or sub-region. The issue is whether this is the right place and scheme to meet that need. The views of strategic stakeholders is that it is not, or it is suboptimal. The ideal location is urban rather than rural, and co-located rather than isolated. It is a standalone proposal. There are no other grass pitches creating a hub. It is not on a school site, which would optimise daytime use. There is some doubt whether local clubs are leading demand for it. The appellant makes much of the interest of Sky Blues in the community to effectively lead the project. But there is no agreement in principle and no real commitment to assuming the risks of the project. Two of the key club users identified by the appellant are at the extreme edge of the defined catchment area and only fall within it on the basis of a 20-minute catchment replacing 5 miles. The revised rugby playing pitch strategy is due to be published by the end of the year. This will set out an action plan for the future of 3G pitches in the borough. The urban area is favoured by Sport England. Indeed, Brandon is not part of the current discussions with stakeholders and will not form part of any future action plan. Against that, it is the case that Brandon is currently the only show in town. It meets need in the short term. The question is whether short-term opportunity trumps longer-term strategic planning. We say it's more important to get the provision in the right place, or at least not in the wrong place. This is critical in terms of long-term sustainability. There is genuine doubt as to the long-term sustainability of the proposal when users from the urban areas have opportunities to move away from Brandon to new facilities closer to home and more convenient locationally. There is a real risk that Brandon 3G could become a white elephant, which would be the worst of all worlds. The stadium would be gone, and the 3G pitch become a liability at worst or underused at best. The financial model relied on by the appellant shows a deficit in year 1. Sky Blues in the community have no commitment to assume responsibility for this deficit. This casts serious doubts over the viability of the 3G pitch proposal. It's vital that the planning obligation, which provides for the provision and operation of the facilities, places all the risk with the appellant. The Council has not the resources nor the willingness to be the step-in operator of last resort. Can I just add there, we hope, thanks to the very welcome negotiations this morning, that the revised 106 will in fact deal with that point. Main issue 5. Whether the benefits of the alternative sport provision outweigh the loss of the former speedway use. This issue goes to NPPF 99C and to Local Plan Policy HS4C, third exception. But there is a preliminary issue. Is redevelopment by housing and a 3G pitch facility development for alternative sport and recreation provision? Sport England believes not. In paragraph 99C, we submit that the word for is important. 99C does not say development with or including alternative sports and recreation provision. We submit that the development here is, as a matter of planning judgment, for housing development with a 3G pitch added. The provision of 3G pitch does not require the loss of the stadium. It's the housing that results in the loss of the stadium, as the history of the redevelopment scheme here shows. But otherwise, Issue 5 presents a decision taker with a straightforward planning judgment, taking into account relevant considerations, including the numbers of people or users involved. The appellant points to the greater number of participants with the 3G pitch, but the council points to the greater number of spectators with the stadium. We submit that 99C does not indicate that sports takes any precedent over recreation. Furthermore, the balance here is not purely a numbers game. The social value of the provision. The provision here is to replace a scarce, iconic stadium that has a national pedigree and heritage with a relatively more common local 3G pitch. The quality of provision. Obviously, the stadium is in a suboptimal condition at present, but the evidence is that it can be made fit for purpose. The likely longevity of the provision. There are risks in either case. What's likely to happen if the appeal is dismissed? In that event, redevelopment for housing would be off the table for the foreseeable future, until, at the very least, it had been shown to be truly surplus to requirements. The only proposers of recommencing use of the stadium for sport and recreation at present are SCS. The appellant has shown no interest or expertise in doing so. Mr. Hunter's attempts to buy the site in 2017 and 2020 appear genuine, and it has not been suggested otherwise by the appellant. SCS, or indeed anyone else, should be given the opportunity to bring the stadium back into use by the appellant. A legal agreement between the two could protect the appellant's long-term commercial interest in the site should SCS fail, either through an overage clause or a reverter in the event the sporting use fails to persist. The weight the appellant seeks to give the provision of the 3G pitch emphasises that it is to be provided under a community use agreement, but there remain many uncertainties. Who will be the parties to the agreement? How will the agreement be enforced? What happens if the community user needs to walk away? Mr. Hooper concludes that the stadium is not a community facility for the purposes of protection in Local Plan Policy H3. However, the stadium is expressly protected under Neighbourhood Plan Policy at F1. And we submit that the answer to main issue 5 is plainly that the alternative 3G pitch for sports provision does not outweigh the loss of the former speedway use. Main issue 6, other benefits. The task here is to identify the benefits and the weight to be given to them in the planning balance. If the site is to be redeveloped, then as previously developed rather than a greenfield site, it would be more of a benefit to do so. The delivery of further market housing is a benefit. The Council's housing land supply position was initially agreed at 5.6 years. During the inquiry, the annual update's been published, raising the supply to 6.1 years. But the Council does not contend the difference is material in terms of the weight that should be given to the benefit of delivering market housing. The development would therefore assist in boosting the supply of housing, although in circumstances where the local need is not pressing. Mr. Stevens gives this benefit moderate weight, which we submit is appropriate. Indeed, it was accepted in evidence in chief by Mr. Hooper. Although the housing mix is not consistent with Policy H1, it is acceptable in this rural location. This matter is neutral in the planning balance. Affordable housing. The planned period affordable housing need in the borough has not yet been met. The HEDNA shows an outstanding need. Again, the delivery in the year 22-23 has been identified during the course of the inquiry. The Brandon local need is not as great as the appellants had assumed, and there is another local housing scheme delivering affordable housing. Having said that, any affordable housing delivery in the borough is worthy of weight, and Mr Stevens gives the benefit of these 25 units significant weight. Mr Hooper gives it substantial weight. Economic. Core document 3.6 quantifies the direct and indirect jobs in the construction phase, and there is an update at Mr Hooper's para 6.8 in Appendix 11. Mr Stevens gives this benefit limited weight. Mr Hooper gives it substantial weight, but it is the net economic benefit that needs to be taken into account if you, Madam, find, as we submit, that a revitalised stadium is also able to contribute again to the local economy. The appellant claims as a benefit a reduction in noise and dust and antisocial behaviour complaints. However, the data in Appendix 6 shows that during the years of stadium operation, there were numerically very few 2 dust and 1 noise on average a year. By contrast, the empty stadium generated many more complaints of antisocial behaviour resulting from the appellant's poor management of the site. Although the use of the 3G pitch could be controlled by conditions, some neighbours are bound to complain. We submit this issue is broadly neutral in the planning balance. There's no doubt that some biodiversity net gain will be achieved that meets the current policy requirements. The evidence suggests a habitat net gain of 33.87% and hedgerow net gain of 369.5, with an overall BNG net gain of 16.28. However, that will all depend on the final scheme that's brought forward. We submit that at this stage Mr Stevens is right to give this benefit limited weight. The scheme would deliver more public open space than would strictly be required to make the development acceptable in planning terms. It would also be available to off-site residents, but there's no evidence that there's a particular local shortage of public open space. The provision of public open space is not therefore a benefit, attracting more than minimal weight. So the overall planning balance. The scheme would reuse previously developed land and comply with local plan policy GP3. The appellant's landscape visual impact assessment findings and conclusions are largely uncontroversial. Any harms caused by the loss of trees can be compensated for by new planting. This matter is therefore neutral in the planning balance. But for the reasons given above, the breaches of local plan policy HS4C and neighbourhood plan policy LF1 mean that the proposed development ought to be regarded as being contrary to the development plan as a whole for the purposes of section 38(6) of the 2004 Act. And we submit that there are not material considerations of sufficient weight to indicate a different outcome. Indeed, we say the development would be contrary to paragraph 99 or 93 of the MPPF, fortifying the development plan conclusion. The acknowledged benefits, particularly in terms of affordable housing, support to the local economy, and the new 3G pitch do not, we submit, come close to outweighing the loss of the stadium. The circumstances in which the benefits of the 3G pitch can properly be taken into account as a benefit in the planning balance needs careful consideration. If the appellant succeeds in establishing that the stadium is surplus to requirements under 99A, then the 3G pitch is not needed to make the housing development acceptable in planning terms, could not therefore be taken into account as a benefit. On the other hand, if the appellant makes out a case under 99C, then the 3G pitch would be a requirement. Conditions and obligations. I wrote, as it turns out prophetically, we do not anticipate any serious dispute on conditions. The appellant has agreed to all the planning obligation contributions requested and listed in the Rugby Borough Council and County Council soil compliance statements. The inquiry has identified some drafting amendments to ensure compliance. The Council has also sought changes to the step-in provisions in the event the management company of the 3G pitch fails. Plainly, these terms need to give the Council the prospect of succeeding where the management company has failed, and we've now got that. The Council is no longer supporting the NHS funding gap contribution. This has been the subject of separate legal submissions, which at paragraph 13 listed our criticisms of the NHS Trust's case. Using the same headings, we now submit as follows. And the first sentence in italics is the heading from the earlier submission. There is now some further. Firstly, it does not explain to what extent population growth is taken into account in funding passed on to the NHST by the CCG or ICB. There is now some further clarity. Mr. Gilks told the inquiry that ONS projections for local organic growth are a part of the formula used, but not growth resulting from in-migration by residents of new houses. The NHS Trust has discounted the costs it claims, see the spreadsheet, by 20% on the basis that those qualifying for affordable housing on the appeal site are likely to be existing residents or patients of the Trust, and therefore people for whom funding is already received. Ms. Casey did not demur from that proposition. But there remains a gap in the Trust's evidence in respect of those who will occupy the market housing. We are asked to believe that the answer is that we should assume that all will be new patients. That is just not credible. New households form all the time as family unit relationships form or break up. People move from the rented to home ownership sectors. A decision taker cannot be expected to summon further discounts to the claimed £133,000 out of thin air in the absence of an evidence base, particularly in cases where the impact claimed for is relatively novel and not well established by custom and practice. Next matter, it does not explain what funding it does receive to provide services to new residents during their first year of occupation. It's apparent from the Leicester and Worcestershire cases that a key issue for Mr. Justice Holgate was the lack of any analysis as to how much of the claimed contribution, here the 133,000, was in fact already covered by growth assumptions in the ICB funding agreement. That issue has not been grappled with. Mr. Gilks could not provide an answer to this question in cross-examination. There is no doubt that part of the funding formula relates to growth, but there is no clarity on how much. At the end of the inquiry, we are no better informed. Next issue, it does not explain why the annual negotiations for a block contract do or did not, or could not, take into account or address population growth when such negotiations are not precluded by the funding rules. That the rules governing annual contract negotiations do not prohibit such an approach is beyond doubt. Mr. Justice Holgate said so, and Mr. Gilks confirmed it in examination in chief. The reason given in cross-examination as to why the funding formula does not better reflect the reality on the ground, that there will be additional patients in additional houses, remains unsatisfactory. First, it was said the numbers are not capable of prediction, but this is plainly not correct. Ms. Casey explained that all sorts of organisations do just that for a variety of reasons, and that monitoring data is regularly collected and reported, including to central government. There's no reason why an NHS trust or ICB should keep itself in ignorance. And then it was said the ICB will not agree to funding on that basis. But this is a self-fulfilling prophecy. In any event, Mr. Gilks confirmed in cross-examination, Mr. Gilks confirmed in evidence in chief by Mr. Goatley that the question had never been asked. Paragraph 13 of our legal submissions also dealt with the situation in which any funding gap is demonstrated. The issue, why it was not able to project increases in population arising from new housing in its area as part of its negotiations with the CCG or ICB, the answer appears to be that it's because it had no confidence that such an approach would be looked on favourably by the ICB. We say this is no answer. Next, the issue of what the Trust has done to address the systemic problems in the way national funding is distributed. The answer is not very much. Apparently the case is being made to the Department of Health that the existing model has difficulties or deficiencies, but the Trust will not draw a line in the sand and bring matters to a head. Next, why the Trust did not participate in the development plan making process and seek to have the requirement for funding gap contributions identified within the local plan. There has been no explanation offered. And lastly, why individual development sites should address that problem. Based on the risk assessment, the answer seems to be because no one else is. In evidence in chief, when being asked questions about impacts, Mr. Jilks said, "I can't point to a worse outcome for an individual new resident as a result of the funding gap. There is no infrastructure or expenditure, pooled or otherwise, identified by Mr. Jilks, on which the £133,754 would be spent to deliver the outcomes for residents of the appeal site that can be monitored and assessed." Mr. Jilks confirmed in cross-examination that the issue for him in respect of the funding gap is all about risk. Previously, where trusts were funded on a model in which money followed the patient, there would not be and could not be a funding gap risk to the trust of the nature now claimed. The risk, if it lay anywhere, lay with the ICBs or even the Department of Health. However, that model has changed. Now the risk lies with the trust. It's not happy. It seeks to transfer the risk elsewhere, to the development industry. In truth, its quarrel is with the funding model. There is, so far as this inquiry is aware, no impact assessment that indicates that central government is content with that situation. There's no planning policy guidance or joint guidance with the Department of Health, as there is with the Department for Education in respect of schools infrastructure. Mr. Jilks confirmed that the NHS Trust's funding formula changed as a result of the pandemic. On that basis, it can change again to address any perceived short-term gaps which are wholly down to the funding formula methodology. Finally, Mr. Justice Holgate confirmed that if there is a gap, then its size needs to be identified and justified. For the reasons given above, it's not been identified. Further, it assumes contracting staff at premium rates. As Mr. Jilks acknowledged in cross-examination, if the trust could be given 6 months' notice of new houses being occupied, there would be no reason to do so. That it is plainly possible, as Ms. Casey explained. If there is a funding gap, it's plainly not £133,754, and no other figure has been contended for until the new evidence submitted with the Trust's closing submissions, which suggests a figure of 6.4 million. This is frankly bizarre. Firstly, it's new evidence, which at this very late stage should not be accepted. Secondly, it casts doubt that the Trust has any real handle on what the funding gap really is, or on what basis it should be evidenced. Just pausing there, that's a reference to the 3 documents you've got. When you have the opportunity to read the closing submission, you'll see that it includes reference to an Excel spreadsheet. And the figure in the spreadsheet is 64 million. Thus, Dr. Bose submits, well, 133,754 is so far below 6.4 million that you ought to wave it through. We say that's bizarre. So in conclusion, in the overall planning balance, we accept the site is previously developed land and complies with local plan policy GP3. However, the breaches of local plan policies HS4C and neighbourhood policy LF1 mean that the proposed development ought to be regarded as being contrary to the development plan as a whole for the purposes of section 38.6. Development would also be contrary to para 99 or 93 of the MPPF. And in the Council's opinion, the benefits of the development scheme do not collectively amount to material considerations that indicate a different outcome, so the appeal ought to be dismissed. SCS and its supporters ought to be given the opportunity to bring back racing to the stadium site.
Right, thank you very much, Mr. Richards. 50 minutes, that's pretty good going. Right, Mr. Goatley. Right, thank you very much. Oh, it looks worse than it is. It's single-sided, isn't it? It's not double-sided.
The council photocopy, we did it single-sided deliberately to give you a hard
That's okay. You haven't given me a heart attack. The first thing I checked was it single or double-sided. Right. Right, okay then, Mr. Gatley, when you're ready, please.
First of all, if I may, I can deal with response to the two closing submissions of Malone and Friends. I'm trying to deal with those as succinctly as possible. First of all, Mr. Humphreys, and I've got, I think, 8 points in respect to Mr. Humphreys, and I'm going to deal with these by reference to the paragraph numbers in which they appear. I'll take similarly the approach with Mr. Richards when I come to that in a moment. The first is in respect of paragraph 17 of Mr. Humphreys, a bafflement with regard to the position at Swindon. Mr. Hooper and, to that extent, Mr. Osborne explained the position with regard to Swindon, that is a different set of proposals. It's for a mixed form of development, not simply what you can do with a existing speedway site adjacent to a residential area. Second point, if I may, and that is on page 10, and it's paragraph 48A. This is part of a combination of features seeking to indicate that the planning system somehow takes up some form of presumed position against an appellant or developer in these circumstances. I would invite you to reject that contention. That which is at 48A, dealing with the question of the permitted development order, that deals with permitted development, does not deal with what we're dealing with here. And as will become apparent in due course, this rather hazy exercise of seeking to drag over, elide, or conflate propositions from elsewhere is not of any assistance to you as the decision maker here. It is plainly irrelevant. In the same guise, if I may, that which is at paragraph 49, and this is in context of the Welling-Hadfield case, a case which is directed with respect to other matters. You've got a copy of the Welling-Hadfield judgment, and I don't propose, if I may, to take you at any length through that, but perhaps to give you the relevant paragraph references in that judgment for you to be able to pick up matters for yourself. There are a number of them in order to be able to understand the points which I'll come to shortly, but particularly, first of all, paragraph 73, and I'm going to take you to some other paragraphs, if I may, paragraphs 41, 43, particularly 54, 66, 69, 79, and 80. Now, the reason why I've dealt with that relatively extensively in terms of paragraph references is lest you are left in any doubt as to the distinctions between the case that was before the Supreme Court there and the case which is before you now. The case that was before the Supreme Court was a circumstance where there was a deliberate attempt by means of concealment to seek to utilise what is in effect a statute of limitation in order to obtain a benefit to which that particular appellant, as it was not entitled. That was the public interest, and a public interest that was very specifically circumscribed by the Supreme Court. And if you have a look, please, at particularly paragraphs 54 and 73, which deal very particularly and precisely with those points, and make clear that you have to look at it in context of the particular matters in question. We have a wholly different class here. What it is, in essence, being suggested is that by reference to the way that the third party, and for that matter, the LPA, now seek to characterise a position, that somehow there is a disentitlement to be granted planning permission by reference to the approach set out within both the Planning Acts and the policy framework. With respect, that is a wholly erroneous approach, erroneous not only as an approach, but erroneous and unjustified in law. The same point is raised not only in paragraph 49, but also in paragraph 153 of Mr. Humphrey's closing. That's allied with a second point, which, because there has not been an appeal pursued, that therefore in those circumstances the proposition of presumption in effect against the appellant should be maintained. Mum, you are aware that in the circumstances here, yes, there was a PCN issued. Arising from that, there was an appeal, and consequent upon that appeal being lodged, but not pursued, the council and the appellants chose effectively to drop hands. It's a matter I'll return to in terms of Mr. Richards' closings in due course, but to suggest that that is a matter that simply means all of the apparent guilt for which the LPA now contend and for which SCS contend, and that somehow affects the judgment before you, that I respectfully suggest that ought to be rejected. An allied point only within Mr. Humphrey's argument is at paragraph 50. And that is that irrespective of the law, that has an implication or consequence to the interpretation and application of other policy within paragraph 99. That, with respect, is erroneous and wrong-headed. It's certainly not justified, whether by the authority cited or otherwise. If I can take you to paragraph 58 of Mr. Humphrey's evidence, and that was the evidence of Mr. Hunter. It's a matter which, to a degree, is also contended for by Mr. Richards. If I can respectfully invite you in due course, when we come to it, to look at paragraph 70 of my closing submissions, that deals with that. In respect of paragraph 66 of Mr. Humphrey's evidence, that deals with the Farrow-Walsh report. There is an exercise of reading down and minimisation of that report, to a degree both by him and by Mr. Richards. I would invite you to reject that. The reason being is that, for the reasons of Mr. Richards, of you looking at the best evidence, that is both the best and the only evidence before you as to the structural condition of the stadium, and has not been the subject of any contrary evidence to indicate that it is in any way incorrect or unreliable. That is important with respect to understand the condition of the stadium. Paragraph 96 of Mr. Humphrey's evidence refers to the various attendance figures, and if I might observe that these particular observations I make are deliberately restricted and not seeking to go forensically through all of the matters raised by Mr. Humphreys, but there was no evidence-based data to justify what Mr. Carter said. It all appeared to be on the basis of one person had spoken to another on some unstated occasion, and that was what the output was. That, when it came to the exercise undertaken, for instance, by Mr. Eadie, and for that matter, Mr. Osborne, they did actually both identify figures and did condescend to such. If I might turn to paragraph 109, dealing with affordable housing, there's a criticism raised about the Section 106 obligation. With respect, I would invite you to find that series of criticisms misplaced. That the 106 obligation, the reasons given by Ms. Chapman, is in entirely conventional form, and essentially it delivers that which is in the written form. Paragraph 111, and to a degree this is allied with a point within paragraph 142, indicates a conceptual misapprehension on the part of the Rule 6 party, which appears to, in part anyway, be either shared or to have infected the local planning authority via Mr. Richards. And that is, if you have a benefit which arises from development, whether or not you have regard to it or not. The first point is whether you have regard, and second point is whether you have the weight that you give to it. If one looks just ahead, because it is the same conceptual point, to paragraph 142, that was in context of open space, and it said that open space provision cannot be given any weight because it's not necessary to make the development acceptable. Now, essentially what is being contended for here is that if one has one of these features, it is not a feature to which you can have regard because it is policy compliant. Once you've had policy compliant, then in which case it's policy compliant. So what? However, if you go beyond that which is policy compliant, you must ignore it because it is in excess of policy. I would ask you to figuratively keep that in mind when looking at matters such as BNG. Is it right to say that no benefit to which a decision taker can have cause for consideration arises because a development gives rise to 100 or 50% biodiversity net gain as opposed to 5 or 10%? It is a matter of, I'm afraid, conceptual illogicality on behalf of the Rule 6 party and the LPA, which we would invite you not to follow. If a matter is relevant to your determination, is material to determination, then you are entitled to accord that appropriate weight, rather than to be forced into what may be regarded as a rather surprising ground loop, giving rise to unforeseen and illogical consequences. I make no observations with regard to the case law in Appendix A to Mr. Humphrey's closings. You have a series of appendices, and I'm not going to seek to pursue a further full forensic examination of them. You have the material before you elsewhere, but we would invite you to look at that material rather than necessarily that which is contended for in these particular closing submissions. If I can turn next, please, to the closing submissions of Mr. Richards on behalf of the Local Planning Authority. Paragraph 19 is essentially a recapitulation in factually varied form as to how racing came to cease. I'd invite you, if I may, to look at Mr. Hooper's paragraph 5.61 and Appendix 1, which gives the chronology of events, including that when the site was acquired, and there was in fact a lease which was granted, and that lease was explicitly given back by the racing club. So to suggest that it was the current owners have shown no interest in resuming racing is either factually incorrect or certainly to do offence to the chronology which is therein set out, and which I don't understand to have been the subject of an alternative narrative and criticism. Within paragraph 20, there is an elevation of the commitment of SCS. Now, let me be quite clear. I make no criticism of SCS's commitment and enthusiasm. Our concern and our criticism relates to realism, but simply as Mr. Richards has done, to allied commitment and realism itself does no service to the proper appreciation of this case. The second point within paragraph 20 is a reference to Mr. Hunter and his apparent deep pockets. With respect, we would ask you please to look at paragraph 70 of my closing, and indeed, if you would look back please to the cross-examination of Mr. Hunter and what he said. Mr. Hunter is not just simply throwing money at this. Quite properly, he is a businessman, and he will look when he has the material before him to ascertain what it is he's prepared to commit and in what circumstances. Take no issue with that as a completely sensible and rational approach, but the idea that he is just some kind of fairy godfather who is going to visit money on this irrespective is, I'm afraid, not justified by the material before you. It's said within paragraph 20, the appellant, and indeed that's repeated later on, that the appellant has now not allowed SCS onto the site in order to make any form of detailed assessment. That's, with respect, that's not correct. And indeed, Mr. Hooper explained that with regard to their own application, no, but there was absolutely no rejection or restriction upon the ability of SCS to seek to come onto the site for the purposes of that exercise. They just simply never asked. I would make the observation that the council has had access to the site on numerous occasions and itself has not sought to undertake any exercise to justify any of its rather remarkable contentions now made in these closing submissions. That is, to put it at its lowest, highly surprising. Now, Mr. Richards then wanted to have apparently some fun in terms of position for my questioning of Mr. Morris. You will have heard the questions I asked, not just of Mr. Morris, but also of the other witnesses as well that were advanced. It is not my job to seek to, figuratively or otherwise, lay gloves on, nay, beat up witnesses, whether at the implied behest of Mr. Richards or anyone else. I asked questions to an effect and purpose. I hope Mr. Richards was listening to the questions I asked and the answers I obtained, and what Mr. Morris was and wasn't able to help us with. And with respect, Mr. Morris was not able to help us with most of the questions relating to the economic circumstances as to how you would be able to resume racing at that particular stadium. That is not a reason to be dismissive of Mr. Morris or to figuratively in some way put a glove on him. And I hope in those circumstances that is understood, not only by you, but by others too. Now, you're invited in paragraph 25, and indeed, I think in succeeding paragraphs, to seek to adopt an approach to policy which, well, to put it mildly, bobs around a bit. The cases advanced related to paragraph 99, but because that obviously was not availing the council during the course of their case, they decided to go to policies 92 and 93. With regard to those policies, those do not avail the local authority in any event. But insofar as they are said to be prayed in aid, they don't take the authority's case any further forward. Now, the same point regarding appellant denying SCS the ability to inspect the site is made at 29A. For the same reasons I gave earlier, I would invite you to reject that as unjustified and erroneous. Similarly, paragraph 31, which seeks to create a different narrative as to what occurred. Now, it's suggested that you are entitled to alter the weight attributable to any of the factors referable to the consideration of this case on the basis of what the council now contends, having decided to indulge in the withdrawing of its PCN, but on the basis that they say rationally you can do that. Once again, somewhat surprisingly, the council is asking you to tread into an area of legal error. To alter weight in context of this and in these circumstances would not be legally rational. It is not necessary to your decision. It would not be justified. And with respect, this casting around for other examples, such as paragraph 196 of the NPPF, really doesn't help. Those are policy imperatives directed to particular circumstances, quite properly, by those who are providing policy, not relevant to you here. Paragraph 32 deals with the absence of any resolution by the council. I would simply invite you to read or reread that, but that is really just a very elaborate narrative for confirming that the council has no plan or resolution to do anything in respect of this site. With regard to paragraph 36 and the desirability of this pitch, it's put in contention that because it's not a school site, that is one of a concatenation of factors whereby there should be some doubt as to the prospect of this proposal succeeding. Of course, the fact that it's not a school site also means that it would not have an inhibition on its use by the wider community that inevitably arises by reason of the fact that if it were a school site, the interests of the school, and for that matter the school population, would have to be taken into account, which may, if not preclude, materially inhibit the use by the community. Now, it's said that in paragraph 38, this development would be a trumping of long-term strategic planning. Far from it. There is currently no playing pitch strategy in play, and it's pursuant to that playing pitch strategy that an action plan would be provided. To suggest that this particular site will not be part of any future action plan is an interesting exercise in predetermination, which I will simply leave legally for another day if need be. But I would invite you, please, not to place any reliance upon it. Paragraph 39 seeks to throw up a miasma of dirt in order to suggest that there is some form of doubt as to the prospects of this proposal. This proposal has been carefully scrutinised by KKP, who have provided a business plan, and business plan that shows precisely how not only it would and could be delivered, but also where funding streams would come from. The most we get is that at some stage a real risk it could be a white elephant. In reality, the only person that's saying it's a real risk of a white elephant is Mr. Richards. There is no evidence to support that contention, either from his own side or, for that matter, from the appellants. The next is rather more worrying, which is paragraph 41, which is again seeking to invite you into legal error on the interpretation of paragraph 99 of the NPPF. It's suggested that the development, it's novelly suggested that the development is not one for alternative sports and recreation provision, and that therefore that component simply falls out of account by an interesting sleight of hand. With respect, I would invite you to reject that. There is no warrant for that, nor is there a warrant for the contention that when one is looking at paragraph 99, one should somehow elide that which is directed to participants to that which is amenable to consideration for spectators. The two are distinct, and there is no evidence that paragraph 99 is intended to support spectators. Now, you are also invited by a cri de coeur to allow an opportunity for SCS to be able to in some way have some form of deal on some form of newly positive basis, such that they would have some kind of last go at being able to provide a stadium at Brandon. With respect, that is not a proper aspect of policy. That is not a proper aspect for the consideration of this proposal. And the material before you, whether brought forward by SCS or asserted by my learned friend, does not assist you in that regard. Ma'am, on that basis, I now propose to turn to my own closing submissions. For the reasons I've explained a little earlier, I'm going to try and deal with some matters in more summary form. I'm happy to read it in its entirety, but if I can identify those matters which I'm proposing to read and those matters which I will leave to you to read at your leisure.
very happy for you to leave certain sections for me to read. If you just summarise the basis of those, that's perfectly fine. Thank you.
Thank you very much, Mum. The introduction, we all know what the proposal is for and the one reason for refusal which we're dealing with relating to the Greenbelt. Within paragraph 4, I set out a description of the character of the site and its surroundings and the extent to which it's surrounded by either built form development or woodland, and the nature of the area in which it sits. That element of physical and visual containment is a matter which Mr. Chard has referred to, and clearly you will have had the opportunity from your site visit to make your assessment in that regard. The various character areas for landscape assessment are set out in paragraphs 6, 7 and 8, which explain the basis upon which Mr. Chard approached matters, and ultimately the conclusion reached, which if I can take you to paragraph 9, the developed nature of the appeal site, enclosed boundaries and existing residential development within the immediate setting mean the site has a much closer relationship with the existing settlement edge rather than being part of the more rural countryside located beyond the woodland to the north. As Matthew Chard explained, the site is a detracting void in the landscape with a dilapidated stadium which is degraded and out of kilter with the locality. And you have, among other things, the site appraisal and the photographs that go with that. Now, one matter which is not in contest between the LPA and ourselves is that the site is PDL. That's set out not only in Statement of Common Ground but also within the officer's report, but there is contention between the appellant, and to that extent the local authority on one hand, and Mr. Carter and SCS on the other, albeit during the course of cross-examination, indeed observations you made, that appeared to move in a rather more consensual direction. That said, you have, among other things, the definition in paragraph 14 of that which constitutes PDL, and indeed what some of the components are. And we got into a slightly strange discussion about hard standing and what you find at airports and the like for, I suspect, car parking there. I'm not sure that those points raised by SCS necessarily assist you unduly, but we simply contend the site is previously developed land in the Greenbelt. Turning, if I may, to paragraph 16 and following, the sensitivity study undertaken by the Council indicates that the views into the parcel are very limited, with a low level of intervisibility with a visual relationship to the settlement. Ma'am, you have the remainder within paragraphs 16 and 17, which again stand up the proposition which I identified a little while ago in terms of Mr. Chard's own assessment of the site. The site itself and its detracting features, those are relevant to you for the purposes of assessment, as are the extent of the existing structures, among other things informing, as they do, your assessment, both the site and that which is proposed in context of the development. Now, turning to paragraph 19 and following, what we see is policy GP2 and thence also the 5 components of paragraph 138 of the NPPF. But the fundamental aim, as we see in paragraph 21 of Greenbelt policy, is to prevent urban sprawl by keeping land permanently open. Now, there was then a further examination of what was described as broad area 2, and that the site is but a small component of that, and what the nature of the assessment of that particular parcel arising from that study for the purposes of Greenbelt assessment. Now, quite clearly, the proposed development will result in a reduction in the area. The large linear monolithic buildings will be removed and replaced with development that's smaller in mass and more appropriate of domestic scale to reflect the existing character of the area and the immediate locality. Now, there's then an explanation of openness, and there is recitation of three authorities, Timmins, Turner, and Samuel Smith as well. My learned friend, Mr. Humphreys, has provided you with those authorities, and I don't believe it's necessary to go further. You have two summary assessments from him and from us for the purposes of that in order to assist you, but you have, most importantly, the authorities themselves if you need to be able to undertake any particular assessment in light of those authorities. Now, as we accept, there will be, this is paragraph 29, a change to openness from the proposed development, and that's by definition. But that when one looks at the overall assessment, there would be a positive outcome, or at the very least, a neutral one. And indeed, similarly, that's the view taken by the council's officer in her report when it was put to committee. Now, arising from some of those earlier authorities, we have both the spatial assessment in terms of, among other things, of comparative coverage, and indeed what you will see and from where, together with a visual assessment as well, and the reference there to Mr. Chard and what he has said about visual openness, including, among other things, from the public rights of way. And the references in paragraph 35 that Mr. Chard indicates that the overall change to the openness characteristic of the Greenbelt would be highly localised in extent and partly mitigated through the sensitive design approach which is proposed here. And indeed, so far as public rights of way users and local residents, it is assessed that there will be an improvement. You have the numerical and volumetric percentage alterations, and I don't propose to take you through in any detail. You have had that from previous evidence, and that's where the closing submissions provide those by way of citation. But what there is, in paragraph 36, is the potential for significant benefits arising from enhanced access to and the quality of land remaining in the Greenbelt, particularly in context of the existing dilapidated and degraded brownfield land. Now, the main issue relates obviously to paragraph 99, to which reference has been made. There is no dispute that the suffix provision of the conjunctive or in A to C means that it's only necessary to satisfy one, and the same position applies in context of policy HS4C, which in effect mimics that in paragraph 99. Now, we set out our assessment of those paragraphs and indeed sub-paragraphs. If we look at paragraph 42, breaking down 99A, assessment needs to be undertaken, but there are no set criteria as to what the assessment must look like. Clearly, that's a matter of planning judgment. Secondly, there's no definition provided as to what constitutes surplus to requirements. So again, that's a matter for you. Although Mr. Hooper accepted the onus is on the appellant to carry out such an assessment, it is to be noted that neither paragraph 99 nor policy HS4C explicitly state that. So again, for your evaluation, that's a matter for you to determine on the basis of the material provided before you. And there is no requirement for the conclusions to be unequivocal, i.e. saying it's either an absence of doubt, beyond doubt, or whatever. There can be doubt which remains as long as the standard of clearly showing that there is a surplus to requirements, that clearly standard is met, and that, once again, is a matter of planning judgment for you. Now, on that issue of surplus to requirements, we deal with that in paragraphs 44 and following. It suggests that certain things must be excluded from your consideration. With respect, we haven't proceeded on that basis. And the first of those is excluding that it must be any requirements. if it were to meet any requirements, then taken to its extreme, it would mean that if any single individual felt they had a need for Brandon Stadium for its former purpose, then that would be enough, and that can't be right. Now, Mr. Stevens, when he was asked about this, a person might want to do a variety of things, drive an Aston Martin or live in a grand stately home, and that simply having a desire doesn't make it a requirement that the planning system has to provide for. Now, as Mr. Stevens acknowledged, national policy isn't written in a way to satisfy desires. And where there is a divergence between the parties is whether what SCS contends for is a desire or a requirement, and we say it is plainly the former. It's also clear that whether or not something is more than is needed, a surplus, is plainly wedded to viability. Mr. Stevens accepted that financial realism is a material consideration, but he says it's separate from paragraph 99A. That cannot be right. In any event, the appellant's assessment demonstrates not only is Brandon Stadium surplus to requirements irrespective of its viability, but it's not a viable prospect either. Now, as to the assessment, that's in the form of Mr. Eadie's KKP Speedway viability appraisal of April this year. Speedway being the focus not because stock car racing has been ignored, Mr. Osborne's evidence clearly considers that, but because it's subsidiary. Given that there's no set definition of what comprises an assessment, it's open to you to take it into consideration as part of any assessment, and in any event as a material consideration, all the other evidence that you've heard. Now, you've heard from KKP, a national and international consultancy with particular expertise in relation to planning for sport and leisure facilities. And importantly, Mr. Eadie has not only a wealth of experience carrying out assessments such as these, but was involved in the teams which helped to develop the Sport England Assessing Need and Opportunities Guide, the ANOG, and their planning pitch strategy, and his evidence should be taken in that context. Now, he was clear that in respect of the ANOG guidance, it does not apply to an assessment of the kind he carried out, because it relates to participation in sport, not spectating. As a member of the team that created the guidance, he should know, in his view, was not altogether dissimilar to White Young Green, who remarked in their independent report that although the ANOG principles can be followed, undertaking SNA work for motorsports is also difficult as there are no supply and demand models. Participation is also low, as the sports are mainly about spectating as opposed to participation, meaning that many of the parameters set out in ANOG do not directly apply. Though the stages for an assessment may be a sensible framework, that does not mean there's any requirement to use them in this context. And there are, as Mr. Eadie explained, clear differences when dealing with spectating, to which ANOG is not directed. And it's not appropriate to try and adopt a document which has been prepared for one purpose for another. Now, Sport England accept the proposed development does not fall within their statutory or non-statutory remit. Mr. Hooper is plainly right that their views should be afforded some weight, but tempered with that in mind. As Mr. Eadie confirmed, they do not have any policies with respect to stadia, nor have any imperative to retain any particular stadium. None of the governing bodies for speedway or stock car racing appear to have any published strategy as to facilities and or stadia either. Mr. Eadie has a specific expertise in areas of work for which there is not a prescribed methodology such as this, and his approach and that of his team at KKP is plainly sound. The assessment is based upon the level of activity that was taking place at Brandon Stadium prior to its closure in 2016, taking into account the reasons for its closure, a review of the existing available research and reports, including the WYG report, an analysis of the national and local market, and current national position in respect of operational stadia, an analysis of other venues and a consideration of environmental impact. Now, Mr. Eadie was criticised as to the extent of the data upon which he replied. However, as he fairly pointed out, there's not a huge amount of statistical evidence upon which to base an assessment of need or an assessment of viability. He explained how his firm had tried to take available statistics and available data that pertains to Speedway, less so stock cars, and look at it, in effect, the trends in the sport, which provides some indication of the current health in the sport, in our opinion. He was clear that his colleague had consulted with operators of Speedway facilities across England, with discussion including conversation with the CEO of Gaming International, the owner of Swindon Robins Speedway, the former chairman of British Speedway Promoters Association, and the coordinator of the Speedway Control Board. They did not go out of the way to try to find a case in support of the appellant, but tried to investigate the case based on the available evidence. With respect, that is a sound approach. Whilst there may be a paucity of data, that does not mean there's an absence of data, nor that an assessment is otherwise than sound. It's also not a criticism that fairly lies at Mr. Eadie's door. The absence of data was also recognised by WYG, who acknowledged that, through no fault of the applicant, clarity surrounding the operation of the stadium and the ultimate viability is still clouded, and that what remains lacking is any clear set of management accounts for the stadium operation separate to the company accounts, which clearly show the operational costs of the stadium separate from the company encumbrance. This is despite significant efforts from the applicant, it being noted that it is unlikely that a true picture can ever be established. What has been rather curious throughout this appeal is that the data has not improved, despite the heavy involvement of SCS as a Rule 6 party, which contains a plethora of individuals perhaps best placed to access such information and who've not hesitated to criticise the appellant's team. Were Speedway and stock car racing at Brandon and elsewhere as vibrant as they claim, it would surely have been effortless to produce verified attendance and participant data and complete sets of accounts from the various venues around the country, which they grasp at as examples of an allegedly thriving sport. You'll have to read what you will into why that's not been done. Instead, what remains is no explicit, specific, and properly verified data to successfully challenge the contentions made by Mr. Eadie, nor the contentions of Mr. Osborne, when they say that Brandon Stadium is surplus to requirements and not a viable prospect. Any estimated figures of attendance and participation at Brandon Stadium prior to its closure and assumptions as to likely attendance and participation were it to reopen based on other stadia has simply not been properly verified by public records. Now, though SCS were at pains to draw out minor errors in Mr. Eadie's analysis, and again you have Mr. Humphrey's closings today, they do not change the overall tenor and legitimacy of what he concludes, that the viability of Speedway as a sport as a whole is severely challenged, the impact of which is that the need for the former stadium to be retained does not exist. It remains that a number of Speedway teams have fallen away since 2016, though 2 others have emerged. There is no clear evidence of success to suggest that this changes the overall picture. The independent review of the sports planning case undertaken by WYG in September 2019 also highlights that motorsport participation has been in decline nationally. Mr. Eadie was not directly challenged as to his evidence that the average TV viewing numbers for the sport fell from 145,550 in 2008 to just 34,000 in 2017, dropping by a further 50% in the 2 subsequent years. Although Mr. Morris talked passionately about Warner Brothers Discovery having paid €100 million over 10 years for the rights to Speedway broadcasting, no evidence was provided by him as to how this impacts the UK, let alone how Brandon might benefit. Mr. Ford's evidence seemed to suggest that for a championship team, revenue would only pay for various fees at source, rather than producing any particular beneficial income, and even then, that would not go to the stadium operator. The appeal site has not fulfilled a role for motorsport for 7 years, in which time the professional speedway team that occupied the site has been disbanded, and the number of professional speedway teams and resultant fixtures has reduced. There's been no evidence at all, save for anecdotal reference to one stock car rider, that suggests that participants have not been able to compete at either speedway or stock car racing since the Brandon Stadium closed. The evidence of all parties appeared to be in agreement that speedway riders are footloose. They're predominantly professional, primarily paid on the points they score in meetings, together with contracted retainers and travel expenses. Clearly, travelling between venues, away from where they might locally reside, is not an issue. There's been no evidence of any professional speedway rider being unable to access a racetrack, either for training or competition, and of the currently 18 operational speedway tracks in the whole of the UK. As Mr. Osborne explains, riders can ride in more than one league, and many also ride for clubs abroad. Indeed, riders in the UK and European teams and competitions include those travelling to the UK and Europe for the season. They're hardly likely to be wedded to Brandon Stadium. Certainly no rider came to or wrote to the inquiry to say that this was so. Similarly, though stock car drivers are amateur, they are paid on performance. There was no evidence provided by any stock car driver, even if one were enough to demonstrate no surplus, to say that they were unable to participate in the sport as a result of Brandon Stadium closing. Any need that might remain can be met from the several tracks which remain. There are no accessibility standards in motorsport, as acknowledged in the 2019 WYG report. Though a number of tracks are some distance, the sport has continued and evolved without the appeal site. With the greatest of respect to SCS, the history and previous fan base is not enough justification to find paragraph 99A or policy HS4C is not met. Even if there were verified data in respect of spectatorship to seek to demonstrate such a need, that would not do so. To the contrary, the policy is plainly directed at participants. That must be correct when one considers the true purpose of both national and local policy on any sensible view. Turn to the question of financial viability to reinstate the Speedway Stadium. Whether considered as part of the consideration as to whether or not Brandon Stadium is surplus to requirements or as a material consideration, it is clearly not viable to reinstate the stadium. The White Young Green report concludes that the former stadium may struggle to be delivered viably in its current state, and given the ownership will be difficult to deliver. It goes on to state, this is different, however, from whether a new stadium operated under a new model could potentially be operational viable. However, as we set out in opening, even that is overly optimistic. The Council do not have any plans for how the stadium could be brought back into use and presented no evidence at the appeal in relation to the future viability of the stadium. It cannot be considered there will be any compulsory purchase of the site by them. It was abundantly clear from Mr. Allen's evidence that the Council rely on SCS's evidence. Mr. Allen continually deferred to them during cross-examination, unwilling, it seemed, to provide his own analysis. It is understood that SCS do not plan, at least in the first instance, to bring back Brandon Stadium as it once was. Rather, they talk of bringing back speedway and stock car racing through a phased approach to reuse, the jumpers for goalposts offer. To support that offer, they produced an estimated breakdown of costs set out in Mr. Carter's proof of evidence. Those costs need to be considered in the context of the current condition of Brandon Stadium, which, ma'am, you will have observed for yourself during the site visit. The only professional evidence in respect to the same is the structural condition report of Farrow Walsh Consulting in April this year, which confirms significant concerns regarding condition of the former stadium, which could not host any form of events without demolition and significant reinstatement. Neither SCS nor the Council have produced similar. Though SCS complained that they have not been permitted access to the site for inspection, Mr. Hooper's evidence was clear. They had not been refused the same. Access was denied for the purposes of surveys in respect of SCS's planning application, but not the appeal. Either way, the Farrow Walsh report is the best evidence that you have. Neither Mr. Allen nor Mr. Carter could detail in cross-examination anything specific about the same with which they took issue. Mr. Osborne was clear in his capacity as an experienced stadium operator that he'd read that report, seen the site post its closure, and there was nothing that made him consider the report to be inaccurate. Frankly, the report illustrates the lack of realism SC have in respect of their jumpers for goalposts pipe dream. It just isn't possible. Though Mr. Carter suggested the grandstand could simply be boarded up, there's been no health and safety or licensing-based assessment to suggest this is at all possible. Mr. Osborne was of the view that it would not be safe. It was suggested by Mr. Carter in all evidence that the grandstand could simply be separated off from the rest of the site with boarding so that use could begin again. That's simply not realistic. No evidence has been produced as to any risk and or health and safety assessments having been carried out by SCS or any other body confirming this would be a possibility. Mr. Osborne's evidence was clear. He did not consider that the SCS hope of boarding off the grandstand to be realistic, and Mr. Hooper further questioned whether or not planning permission would be required to demolish and reinstate the former stadium in part or in whole, and why, if consent were granted, even if consent were granted, it would be likely subject to conditions limiting the operation of the stadium and adding significantly to the cost of the track. Turning to the costs evidence, Mr. Carter noted that the estimate produced by SCS set out in his proof of evidence included a 15% contingency, but he acknowledged this might be an incorrect figure, describing the analysis as informed to a degree. That information appears to have come from a series of sources without any clear verified data to support it, and respective stadia such as Oxford, which was not in the same condition as Brandon when works were required. SCS's costings have not been through any professional analysis carried out by cost consultants or similar. They are not based on any business plan, either sufficiently detailed or at all. To the contrary, the appellant's cost report, prepared by international cost consultants Ryder Levitt Bucknell, provides a detailed breakdown of the cost of the demolition, refurbishment, and construction required to restore the stadium back to a level where it could host the same level of activity as it did at the point of closure in 2016, and the total costs of the works would be some £13.7 million. It is acknowledged this is for more than the jumpers for goalpost proposal, but the appellant's witnesses have made it clear why that isn't a possible option in any event. Even if it were, as Mr. Hooper rightly pointed out, it is possible to compare the two parties' estimates side by side and pick out from them those elements that will be the same. Even then, there is a clear and significant disparity which illustrates the lack of realism on the part of SCS. Mr. Osborne considered a number of options, producing a design and specification matrix, the most relevant of which is the speedway and stock car racing without a stadium customer building. That's at CD 15.5.52. He emphasised a number of items that would be required whatever proposal were taken forward, which adds to costings. He was clear there is no financial justification for the development of speedway racing facilities, and in the absence of a substantial grant of funds for the development of facilities and the subsidy of operation costs, the operation of speedway racing, even where combined with stock car racing at Brandon Stadium, is not feasible at any level. It must be remembered that his notional profit and loss account assumes no rent and is the position if the stadium operator and the promoter were one and the same. But this is not what SCS are proposing. Even if it were, it isn't a viable prospect, but it certainly isn't one when one considers the proposal, at least at present, would involve Mr. Hunter purchasing the stadium and Mr. Ford acting as promoter. Mr. Hunter said himself that were the site to become available for sale, he'd want an evaluation done on it and an assessment of all of the damage. He would want a view from outside parties of, where we take it from there. It is not at all certain that he would purchase the site. When you noted that the project could pose a significant financial risk to him and asked if, depending on outcome, there would be a stage where he considers it would not be viable, he sensibly responded, "There's always a stage." Though he continued on to say that he still thinks racing at the stadium is viable, he hasn't yet had the expert advice he would go on to seek. The appellant has. You have it to read. It doesn't look good. There is no evidence which guarantees any funding or guardian angel philanthropist which will save the day. As Mr. Osborne very sensibly said to the suggestion that breaking even might be sufficient, it's madness, you can't do it. Next, turn to whether the benefits of the alternative sports provision outweigh the loss of this former speedway use. It's very clear the benefits that the alternative sports provision would bring outweigh the loss of the former speedway use, such that the proposed development is in accordance with paragraph 99 of the NPPF, criterion C, and bullet point 3 of policy HS4C of the local plan. That is why, in recommending the planning application for approval, the Council's officers determined the benefits associated with the proposals outweighed any conflict with national and local planning policy. Though policy HS3 of the local plan has been raised, it relates to the protection and provision of local shops, community facilities and services. The Council officers report to committee being clear the local plan of community facilities does not include sports provision. Policy HS3 does not set out that other services that contribute towards sustainability assessment. I beg your pardon? Does set out that other services that contribute towards sustainability of a local settlement are covered by the policy. Thank you for cutting me up short. Indeed. But again, the Council's officers' report confirms that Brandon Stadium does not contribute to the sustainability of Brandon Village, the operation being focused on regional and national sport. The former stadium has not provided any economic benefits to the community since 2016 and offers very little support to economic growth and productivity. The only economic benefit the site is currently generating is the £100,000 per annum cost to the appellant to maintain and provide security on the site. Though SCS suggests that very significant economic benefits would have continued had the speedway not departed from the site, that's simply not realistic. No firm evidence was produced before this inquiry to support that SCS claim. Mr. Osborne gave evidence the typical expenditure of a speedway operation, making clear that seeking speedway racing promotion at Brandon at any level is not viable. Typical expenditure of a speedway operation would be £14,331 per Premiership event and £11,823 for every Championship event and £6,395 per National Development League event. Assuming 20 Premiership events, 20 Championship events and 10 NDL events, that would generate a total expenditure of £587,030 per annum. It is clear the expenditure generated by the former speedway use is significantly lower than the appeal proposals generating construction and operation. And that should be that the majority of spend by the speedway operator is directed to riders, the majority of whom are not based locally, rather than being spent directly with local businesses and people. Conversely, the appeal proposals will result in significant economic benefits which will be felt locally and in accordance with paragraph 81 of the NPPF should be afforded substantial weight. The much needed 3G pitch and associated pavilion will create a community facility but will also deliver an alternative to the former stadium neighbourhood plan defined community facility secured through a community use agreement which could be accessed and used by the local community in which it's sited. The proposed 3G pitch should be afforded substantial weight, and as such, the appeal proposals accord with policies HS3 and HS4 of the local plan and neighbourhood plan policy LF1. Other benefits which are significant, firstly, market housing. We do know that the authority has a 5-year housing land supply, but that's a minimum rather than maximum, and should not count against the development, as Mr. Hooper emphasised. There is a national housing crisis, which is incontrovertible, and there is a need to meet that extent of need for those in housing need, and indeed the national shortfall is in excess of 5.5 million homes. The government objective is to significantly boost the supply of homes, and there is a need to support that. The appeal proposals will result in the delivery of 124 new homes, with a mix that the council considers acceptable. Small and medium-sized sites such as this make an important contribution to meeting that requirement in an area that are often built out relatively quickly. Accordingly, that has moderate weight applied to it. Now, with regard to affordable housing, yes, this provides 25 affordable homes which would be policy compliant. Now, you had the benefit of Mr. Stacey's evidence with regard to that and what the extent of affordable housing need is, including that which comes from the HEDNA, indicating that the need is for 495 affordable homes per annum between 2022-23 and 2031-32. Now, we have a series of statistics as to where there has been either failure or a less satisfactory means of seeking to meet those requirements, and having regard, among other things, to worsening market signals with regard to affordability. And that's why Mr. Stacey's view, shown at the bottom of paragraph 80, is that the authority is facing serious worsening affordability pressures, and one through which urgent action should be taken to deliver more affordable homes. Now, that degree of fluctuation I deal with in paragraph 81 of the closing submissions, including what will be the anticipation of the delivery of affordable homes going forward. Now, we say, for the reasons which we come to as to the substantial weight that ought to be afforded to that. But we have the criticisms raised by SCS, which we've heard of again during the course this morning. I set that out, if I may, in paragraph 82, and I propose to skip that. You know what the position is with regard to the council's view on affordable homes. That similarly is a view shared by the appellant. Now, as to other benefits, the site is currently characterised by crumbling structures and a derelict appearance, and the proposal would change that and give rise to a number of clear benefits, including bringing the site back into beneficial use, which meets, among other things, the substantial weight of meeting suitable, of using suitable brownfield land for providing those needs. Now, although that particular citation deals with sites which are within settlements, and the appeal site is outside the settlement boundary, it is a brownfield site and would be otherwise adjacent to it. And so that is the reason why Mr. Hooper gave that significant weight. Indeed, so would Mr. Stevens. The significant environmental and social enhancements that would arise, among other things, the site is currently not accessible to the public, and that would change. The potential of creating 370% more open space on site than is required by the policy requirement. You've already got my observations with regard to requirements and benefits. Just a point within paragraph 87, the observations again referred to by my learned friend Mr. Humphreys to DB symmetry. We don't invite you to follow that particular approach, nor do we suggest that it's appropriate to characterise this as an instance of buying and selling permissions. But the point goes nowhere. Though it's correct that government policy and law have rejected the buying and selling of planning permission, that's in the context of situations where a local planning authority makes exorbitant demands of a developer, or a developer offers planning gain which is not sufficiently related to its proposal in the hope of obtaining planning permission. And that's not the position here. As is acknowledged by the court, it's well established that a planning authority can achieve, by obtaining the agreement of a landowner to a planning obligation, a purpose which it could not achieve by imposing a planning condition. Clearly also reference to Tesco stores and the vires of the imposition of or seeking an obligation as referred to by the Court of Appeal in Good. It is a planning obligation, what one's dealing with as a matter of contradistinction is a planning obligation which has nothing to do with the proposed development. That form of obligation cannot be a material consideration and then can only be regarded as an attempt to buy planning permission. But where the planning obligation is related to the development proposal in a way which is not trivial, the weight to be given to the obligation in determination of the application for planning permission is a matter within the discretion of the planning authority, and therefore the test within SIL 122 would be met. We have dealt with biodiversity net gain and that which is achieved in context of the proposal, the coherent ecological networks that will be established, and the comprehensive scheme of landscaping. And as agreed by the LPA in recommending the application for approval, those are benefits that hold substantial weight. With regard to the financial benefits that arise in terms of local economy, etc., those are set out numerically within paragraph 90, and I propose to leave those to your reading. We say those benefits should be afforded substantial weight. Turning to the overall planning balance and conclusion, critically, the appeal proposals will deliver 124 dwellings, including much needed affordable properties in a sustainable location, whilst also providing an alternative sports and community facility, significant public open space, biodiversity net gain, and significant economic benefits. And as such, the significant benefits are consistent with the objectives of national, local and neighbourhood plans, and set against even the alleged harm, it's clear the benefits of the development are not demonstrably outweighed. And for all of those reasons, ma'am, you are respectfully encouraged to allow the appeal.
Right, thank you very much, Mr. Goatley. Your voice just about managed to hold out there.
Just about,
to the end.
Just about. I'm sure others were hoping that it wouldn't, but there we go.
Just one point for me before I forget. Can all parties please just send electronic copies of your closing submissions through to the case officer, please, just for our records when you get a chance. Thank you.
Yes, and we propose to upload them onto the website as well, should anybody else want to look at them.
Yeah, that's fine. Okay, thank you, Mr. Richards. Yeah, Ms. Humphreys.
Sorry, madam. When you said the case officer, do you mean Casey or?
Sorry, I meant Pinn's case.
Pins.
Yes,
Yeah,
yes.
I'll do both.
Sorry, yeah, Robert Wordsworth. Yeah.
Madam, just while
Sorry, can the appellant just send a copy to me as well so I can get it on the website? Thank you.
Yeah. Okay.
Madam, just one minor point, or just for clarification, because I think Malone may have misunderstood or mischaracterised the way I put the point. His point 8 in response to my question, which was the distinction that I draw between Regulation 122 in respect of the over-provision of public open space, the 370%. Can I just clarify my position? My submission relates entirely to Regulation 122 in terms of whether an obligation which requires public open space and the transfer of the land to the council, that can't be taken into account insofar as it goes above the requirement which is necessary. It's in relation to 122 that you can't take it into account as a reason for granting permission. BNG is not secured by planning obligation. if it's above a certain level, it's more than 10% or 30% or whatever the position is, then of course benefit can be given, weight can be given to that as a benefit, it can be taken into account. So my point is, and I don't suggest otherwise in my closing, my point is simply in relation to 122. That's the law, that's the legal position. It's not a conceptual misapplication. One might say that the law should be different. One's perfectly entitled to say that. But my position is simply applying the law that we're given by Parliament through Regulation 122. I don't seek to go beyond that, that's all I'm saying. And that's what the DB symmetry in relation to 122 is saying as well.
Right, thank you for that clarity, Mr Humphreys.
You've got my submissions. I'm not proposing to go back on further on that.
You too, Mr Goatley, thank you. Right, so we are just about at the end. Just finally, then from me, cost applications. Any party intending to submit an application for costs? It's not disappointing to me at all, because it means I have to write an additional decision, don't I? So I clearly don't mind. Okay, that's helpful. Thank you to everybody for that. Okay, then. So then all that really leads me to do then is just thank everybody for their participation throughout the sitting days to assist me in this case. It's been a very interesting case for me, something a little bit different. So it's been quite a good few days, really, and I'm looking at a totally different area of recreation and sport, which I have very little knowledge about, but I've certainly gained quite a lot from this inquiry. Also to thank the council for their hospitality, for the provision of the venue here, and the retiring rooms as well. It's been very, very, very good venue for us, so thank you for that. So all that really remains for me to do then is to close the inquiry and to wish everybody a safe journey home.